Good morning. Today is February 19th, 2025. I'm Mark Blank, and this is the Commissioner's Weekly Meeting. Commissioner Gilman, any preliminary comments? Are you ready to approve the consent agenda as presented?
Morning. Nothing to add at the onset, and I would vote to approve the consent agenda.
Commissioner Plant?
I would approve the consent agenda as well.
As would I. Proceeding number 24F-0470T, Larimer Emergency Telephone Authority versus Quest. Mr. Gomez.
Good morning, Commissioners. Can you hear me okay?
We can.
Great, thank you. This matter comes to the full commission for review of an interim decision issued by ALJ Robert I. Garvey on January 24th, 2025. The interim decision denied a motion by Larimer Emergency Telephone Authority and Colorado Council of Authorities, which I'll just refer to shortened as LETA, to disqualify ALJ Garvey, the motion filed on December 11th, 2024. According to the LETA motion, this matter does not arise from any conduct of ALJ Garvey from the current complaint proceeding. However, LETA states that it was ALJ Garvey's words and conduct in a previous proceeding, that proceeding being number 23A-0197T, which was a Quest Corporation doing business as CenturyLink QC application for an improvement plan for the basic emergency service network, that caused LETA to question his impartiality in this complaint proceeding. The complaint proceeding is underlying this motion involves allegations by LETA arising from a wildfire on July 29th, 2024, west of Loveland in Larimer County, that was known then as the Alexander Mountain Fire. In that complaint, LETA alleges CenturyLink's basic emergency service network did not have diverse 911 circuits to transport 911 calls between CenturyLink Central Office in Estes Park and CenturyLink Central Office in Loveland. LETA alleges that CenturyLink's basic emergency service network serving the area lacked both physical and geographic diversity. And as a result, the public in Estes Park and the surrounding communities were facing the potential they may not be able to call 911 and would be isolated. So that's generally the thrust of the complaint proceeding from which this arises. With regard to the LETA motion to disqualify, in that motion, it argues that ALJ Garvey created the impression in a previous CenturyLink application that he may not be impartial in the complaint proceeding based on his statements, interactions with witnesses, and legal counsel and his procedural determinations. For example, LETA notes that ALJ Garvey, without input from the parties in CenturyLink's application proceeding, set the two-day evidentiary hearing to be fully remote, contrary to the practice of other PUC ALJs. LETA counsel, Ms. Tracy Oldmeyer, states that had he consulted her, she would have stated a preference for an in-person or hybrid hearing. Ms. Oldmeyer notes that all parties sent an email to ALJ Garvey inquiring whether the remote hearing could be converted to a hybrid hearing. Ms. Oldmeyer indicates the ALJ replied that a motion showing good cause would be required to change it to a hybrid or an in-person hearing. LETA's motion to disqualify indicates that no party chose to file such a motion. And just real quick, I just want to note that I am using counsel's name here because counsel did file an affidavit with the motion for disqualification along with another person. So because I don't usually use counsel name, but in this case, since one of the affidavits the motion is relying on was her affidavit, that's why I am using her name. Going on, LETA makes the statement that it believes a fully remote hearing benefited CenturyLink. The motion goes on to state that the two-day hearing was concluded in one day. LETA additionally cites a statement by the ALJ in which he believes the case has been laying around for a long time and, quote, you want this to go forward, end quote. LETA believes this statement referred to all parties and takes issue with the accuracy of the ALJ statement, arguing CenturyLink's first application filed in 2023 had been withdrawn and its amended application was filed in mid-February 2024, proposed different projects, and so the application had been pending for only 3 months. Ms. Oldemeyer maintained ALJ Garvey was not neutral and did not treat all parties equally or equitably based on his remarks, which she interpreted as indicating camaraderie with favoritism toward and undue deference toward CenturyLink. Lita claims that 2 individuals sent her separate emails that ALJ Garvey did not appear impartial and showed bias toward CenturyLink. This is contained in her affidavit at paragraphs 18 through 21. However, there was the 2 emails claimed by Ms. Oldemeyer were not included in the affidavit, nor were the parties identified, nor was there a redacted version of the emails provided. Other instances cited by Alita as demonstrating bias and a bent of mind of ALJ Garvey include his recommended decision in the application proceeding, in which he did not, according to Alita, discount their terms, the testimony of a CenturyLink substitute witness, even though ALJ Garvey noted the substitute witness's testimony failed to adequately explain overhead and carrying costs. ALJ Garvey noted the testimony of the original CenturyLink witness. In future hearings, CenturyLink would be wise, according to, this is ALJ Garvey talking, CenturyLink would be wise to ensure that its witnesses are available on the hearing date, or if testimony is adopted, that the new witness is better able to explain these costs. Lita points out that ALJ Garvey joked with the CenturyLink witness about lunch and thanked him profusely for testifying in the proceeding. Lita also refers to various statements by ALJ Garvey for the proposition that he acted as an advocate for granting CenturyLink's application in full. Lita points to colloquy between ALJ and CenturyLink witness on overhead costs and capital costs, presumably for the proposition that the ALJ favored CenturyLink's position. Lita accuses ALJ Garvey of rushing to issue a decision, which Lita argues raised concerns it would not get a full and fair evidentiary hearing. Lita further argues that the ALJ made comments appearing to discourage the presentation of evidence. Lita cites a preliminary discussion regarding the ability to address questions, her ability to address questions related to supplemental direct testimony with the Lita witness. The cited transcript cites ALJ Garvey was willing to allow Lita's counsel to question her on the issue, but to limit the time for such questioning. Lita also cites a portion of the transcript from the application proceeding for the proposition that the ALJ was not interested in relevancy and interrupted testimony to express that view when he expressed concerns regarding evidence dealing with nationwide costs as opposed to Colorado-specific transport technology costs, or questions as to which specific project Lita counsel was referring to in an FCC audit. In addition, Lita takes umbrage with the ALJ pointing out that Lita's counsel had exceeded her 3 hours of cross-examination time. Lita additionally maintains ALJ Garvey expressed annoyance with offers of evidence and argument about evidence that did not support CenturyLink's improvement plan application in full. Lita believes ALJ Garvey did not fully and fairly consider the evidence and the argument in his recommended decision. Lita notes that he did not explain why he was discounting an exhibit in which a number of Colorado's governing bodies requested the commission not rush a decision and deny CenturyLink's application and require 911 stakeholders to go back to the drawing board to further discuss what the 911 governing bodies listed as more cost-effective projects. Lita also noted the ALJ did not address its argument that the 15% carrying costs were prohibited under commission rule. Lita also argues the ALJ found in favor of CenturyLink even though it did not meet its burden of proof. Lita points to a passage in the recommended decision in which the ALJ noted there appeared to be frustration with stakeholder participation from both sides and encouraged the parties to work collaboratively to reach consensus. He urged the parties to keep their animosity in check in order to keep 911 reliable and Colorado citizens safe. Lita supposes that this was directed at it. CenturyLink filed a response to Lita's motion to disqualify, stating that under the high standards for disqualification, Lita's motion and supporting materials are based on disagreement with rulings and decisions in a prior commission proceeding. CenturyLink states the references by Lita are to professionally courteous exchanges on the record, and CenturyLink takes the position that there is no threshold showing by Lita that ALJ Garvey is impartial or of a bent of mind which would prevent him from dealing fairly with the parties in the complaint proceeding. ALJ Garvey issued his interim decision denying Lita's motion to disqualify on January 4th, 2025. Regarding Lita's claim that holding a remote hearing benefited CenturyLink, the ALJ noted that apart from not stating any reason that a remote hearing benefits CenturyLink, Lita failed to explain why it did not make this claim at any time before filing the motion to disqualify. Further, ALJ Garvey noted that 3 days after decision number R24-0334-I was issued, which stated that the hearing was to be held remotely, the discovery dispute conference was held. At no time during that conference was a request made to convert the hearing to an in-person or hybrid hearing. Rather, he received an email from Lita counsel inquiring whether a hybrid hearing was possible. ALJ Garvey responded that any party could file a motion to convert the hearing into a hybrid or in-person hearing, but no such motion was filed. As to Lita's claim that the ALJ showed favoritism toward CenturyLink, the ALJ states Lita failed to note that at the start of the hearing, a request was made by staff to allow for additional live surrebuttal testimony to be presented by its witness due to supplemental direct testimony being filed by CenturyLink after answer testimony was filed. There was no objection from CenturyLink and the request was granted. Further, Lita also requested that it also be allowed to provide live surrebuttal testimony in response to the supplemental direct testimony filed by CenturyLink, which was also granted. While Lita's motion indicates concern with the last-minute substitution of CenturyLink's chief witness, the ALJ points out it was Lita that informed the ALJ of the substitution, to which Lita did not object. Without an objection, the ALJ allowed the substitution and remarked that the substitution of witnesses is not an unusual situation in a commission hearing, and if the substitute witness was unable to answer questions, that would taint his testimony. Lita also cites examples of the ALJ joking with and thanking witnesses. ALJ Garvey replies that Lita fails to understand that the commission cannot function without the testimony of witnesses. ALJ Garvey provides that the role of an ALJ is not an adversarial one. The ALJ needs information to create a full record that will allow for a just and reasonable decision to be made based upon the information provided. He notes that it is his general practice during hearings to thank witnesses for their participation and keep them at ease so that they answer his cross-examination questions that typically occur hours after cross from other intervener counsel. ALJ Garvey provides transcript examples of his courtesy to and thanking other witnesses in that proceeding, including the Lita witness during the course of the hearing. Regarding Lita's list of other actions it claims are indicative of bias or lack of impartiality, ALJ Garvey responded that most of these incidents are evidentiary issues, unsupported statements, or taking issue with the recommended decision issued in proceeding number 23A-01917. As to Lita's specific claim that the recommended decision failed to discount CenturyLink's substitute witness testimony since he was unable to answer some questions, although the term discount is not clarified by Lita, ALJ Garvey states that the recommended decision made it clear that he was not pleased with all of the answers given by CenturyLink's witness and expected better in the future. ALJ Garvey explains that he was tasked with determining if the evidence was sufficient to approve certain projects and costs for the 911 system. Because he found in favor of a party on an issue does not show bias to that party. Rather, it shows that the party met the burden of proof. If a party disagrees with the finding of the ALJ, the proper forum to dispute the findings is an exception, not determining the ALJ was biased. In addition, documents entered into the record speak for themselves, according to ALJ Garvey. Therefore, his determination to not allow those already admitted documents to be read into the record likewise did not show bias. ALJ Garvey states that the ALJ has the duty to control the hearing and then allow only relevant evidence into the record. Additionally, documents that the ALJ deems irrelevant only create a larger record with no benefit and potential confusion for a reviewing court. Procedurally, the ALJ explains a party can object and make a record if they disagree with the finding of the ALJ. If this caused an error in the decision, filing exceptions is the appropriate place to make the argument. ALJ Garvey also notes Lita was the only party to file exceptions to the recommended decision. Lita believes that bias is shown by not addressing certain arguments in the recommended decision. ALJ Garvey states that this is also an argument for exceptions. He notes that the recommended decision indicates all arguments were considered, even if not listed in the recommended decision. ALJ Garvey concludes in denying the motion. Any belief that a different ALJ would lead to a different result is unfounded. He continues that the motion to disqualify in no way changes the handling of this proceeding going forward. ALJ Garvey continues that the above captioned case will be judged on its merits and whether a party has met its burden as it would before any other commission ALJ. So then we come to LIDA's request for a full commission review of interim decision denying motion to disqualify Garvey. In its request to the full commission, LIDA argues that under the applicable legal standard, ALJ Garvey was required to disqualify himself because LIDA's motion and supporting affidavits allege facts from which it may reasonably be inferred that ALJ Garvey may not be impartial. LIDA argues its motion and supporting affidavits were sufficient to show that ALJ Garvey demonstrated a bent of mind requiring disqualification in order to ensure fairness and impartiality to all litigants. And the rest of the request for a full commission review of this pretty much reiterates the information that it provided in its motion, so I won't go through that again. There are several statutes and commission rules specifically addressing disqualification. For instance, commission has its own rule at 4 CCR 723-1-1109. That requires that whenever a party has a good faith belief that a commissioner or ALJ has engaged in a prohibited communication or may not be impartial, the party may file a motion to disqualify the commissioner or administrative law judge. And though such motion shall be supported by an affidavit describing the nature and extent of the alleged prohibited communication or bias. Additionally, two statutes under Title 40 of CRS are also applicable. First, there's 40-6-123(1), which provides that members and staff of the commission shall conduct themselves in such a manner as to ensure fairness in the discharge of the duties of the commission, to provide equitable treatment of the public utilities and other parties, to maintain public confidence in the integrity of the commission's actions, and to prevent the appearance of impropriety or of a conflict of interest. Standards set forth in this section apply at all times to the commissioners, to their staff, including administrative law judges, and to parties under contract with the commission for state business. Additionally, 40-6-124 also provides in part that commissioners and presiding administrative law judges shall disqualify themselves in any proceeding in which their impartiality may reasonably be questioned. And it gives several instances in when that could occur. One is have a personal bias or prejudice concerning a party, and which is the most relevant one here. In looking at case law with regard to this, courts have generally held that in civil cases, a trial judge's decision whether to disqualify himself is discretionary and will not be reversed unless an abuse of discretion is shown. And that's the same standard that will apply here in your review of ALJ Garvey's decision. A judge's failure to disqualify himself in the face of a legally sufficient motion is an abuse of discretion. Finally, the sufficiency of a motion to disqualify is a legal determination reviewed de novo. Disqualification is appropriate when the motion and supporting affidavits allege sufficient facts from which it may reasonably infer that the judge is prejudiced or biased, or appears to be prejudiced or biased against a party or counsel to the litigation. The court, and in this case, the commission, must examine both the actuality and the appearance of fairness in light of the facts alleged. Actual bias exists if a judge has a bias or prejudice that in all probability, will prevent him from dealing fairly with a party. Even where there is no actual bias, a judge must disqualify himself if his involvement with a case might create the appearance of impropriety. In ruling on the sufficiency of a motion to disqualify, a judge must accept the factual statements contained in the motion and affidavits as true and determine as a matter of law whether they allege legally sufficient facts for disqualification. Where the motion and supporting affidavits merely allege opinions or conclusions unsubstantiated by facts supporting a reasonable inference of actual or apparent bias or prejudice, they are not legally sufficient to require disqualification. The record must clearly establish bias, meaning that there must be more than a mere speculation. Statements of mere conclusions cannot form the basis of a legally sufficient motion to disqualify. A motion for recusal based on a subjective belief that a judge is not impartial is insufficient as a matter of law when it is unsupported by factual allegations that would reasonably indicate that the judge is interested or prejudiced with respect to the case, parties, or counsel. The facts alleged in a motion to disqualify must not be based on mere suspicion, speculation, conjecture, or innuendo, nor may they be statements of mere conclusions. Moreover, a judge's opinion formed against a party from evidence before the court in a judicial proceeding is generally not a basis for disqualification. Where factual allegations regarding a judge's conduct during a hearing merely constitute speculation and opinions, there are not sufficient actual events and statements which, if true, evidence partiality or the appearance of bias or prejudice against a party or its counsel by the judge. To permit such allegations to form the basis of a legally sufficient motion to disqualify would be to permit any party dissatisfied with the outcome of a proceeding to file a motion to disqualify and consequently create unwarranted delay and chaos. And the example the court gives in one instance is, for example, disqualification is unwarranted where counsel alleges the judge exhibited an extraordinary impatience and animosity toward party and counsel, consistently in ridiculed questions asked, comments made and objections made by counsel, and interrupted counsel's questions with objections and comments of his own. The court found that even though those were pointed and the judge did express some hostility, that disqualification nonetheless was unwarranted in that situation. When most of the factual allegations asserted in the motion consist of opinion, speculation, and unsubstantiated conclusions, which are legally insufficient to warrant disqualification, the sheer number of these allegations does not by itself make disqualification more appropriate. It is settled law that a movement seeking to disqualify a decision maker must overcome the rebuttable presumption that actions of administrative bodies are regular and valid absent a personal, financial, or official stake in the outcome. There is a presumption of integrity, honesty, and impartiality in favor of those serving in quasi-judicial capacities. Absent a personal, financial, or official stake in the outcome evidencing a conflict of interest on the part of the decision maker, an adjudicatory hearing is presumed to be impartial. The decision to disqualify, however, is within the discretion of the decision maker, whose ruling will not be disturbed absent an abuse of that discretion. Further, judges are presumed to have known and applied the law and are not presumed to have violated the Colorado Code of Judicial Conduct. Judges also have the duty to sit in a case unless the movement has established a reasonable basis for disqualification. These presumptions and duties set forth in statute and rule exist to guarantee that no movement is forced to litigate before a judge with a bent of mind. For instance, the court has held that recusal is necessary only when facts have been set forth that create a reasonable inference of a bent of mind, which prevent the judge from dealing fairly with the party seeking disqualification. A bent of mind sufficient to support a reasonable inference that a decision maker is prejudiced or appears to be prejudiced does not exist unless a movement factually avers that a communication manifested an actual or apparent bias or prejudice against the party or its attorney. So Lita has correct, in concluding, I would say in my analysis that Lita is correct that when ruling on the sufficiency of a motion to disqualify, a judge must accept the factual statements contained in the motion and affidavits as true and determine as a matter of law whether they allege legally sufficient facts for disqualification. However, missing from Lita's analysis for disqualification is that a movement seeking to disqualify a decision maker must overcome the rebuttable presumption that actions of administrative bodies are regular and valid, absent a personal, financial, or official stake in the outcome. Further, there is a presumption of integrity, honesty, and impartiality in favor of those serving in quasi-judicial capacities. Case law, in fact, holds that absent a personal, financial, or official stake in the outcome, evidencing a conflict of interest on the part of the decision maker, an adjudicatory hearing is presumed to be impartial. A movement is further required to show recusal is necessary only when facts have been set forth that create a reasonable inference of a bent of mind, which will prevent the judge from dealing fairly with the party seeking disqualification. This bent of mind, sufficient to support a reasonable inference, that a decision maker is prejudiced or appears to be prejudiced does not exist unless a movement factually avers that a communication manifested an actual or apparent bias or prejudice against the party or their attorney. Analyzing Lita's exhibits and statements in its affidavits to support its request for disqualification. First, Lita states ALJ Garvey set a 2-day remote hearing without input from the parties. Lita claims a remote hearing benefited the applicant, CenturyLink, because of the importance of the issues in the volume of exhibits. Nothing more, however, was offered except that CenturyLink's witness traveled to Colorado to testify from their counsel's office, which is near the commission's building. However, ALJ Garvey, in response to an email from Lita counsel, indicated he would entertain a motion for a hybrid or in-person hearing if good cause could be shown. However, no party chose to file such a motion. There is further no indication that the location of CenturyLink's counsel's building to the PUC was in any way prejudicial to Lita or its witness. Lita does indicate that the witness was at their counsel's office, but I would assume that the inference was that it could have been coached or somehow otherwise helped through the process by CenturyLink's counsel. But however, Lita provides no evidence of that whatsoever. A statement by ALJ Garvey on a motion to compel by Lita was also cited that he believed this case had been laying around for a long time and the parties wanted to go forward. Lita states the application had been pending for 3 months. Nothing further indicates how this is prejudicial to Lita's position in the proceeding. Lita further states in affidavits and provides excerpts transcript from the hearing that the ALJ, through his jovial nature towards CenturyLink's witness and politeness, indicated camaraderie, favoritism, and undue deference towards CenturyLink. Lita states this was supported by 2 emails it received from outside parties, unidentified outside parties. Lita provides nothing more to substantiate this claim. Lita also points to statements from the ALJ when it expressed concern that the last-minute substitution of a CenturyLink witness was of concern. It points to the transcript where the ALJ indicates it is not unusual to substitute witnesses or adopt the testimony or another witness in PUC proceedings, and that the ALJ would weigh his testimony accordingly. However, Lita claims that ALJ Garvey did not discount his testimony. I think of note here is that Lita uses the word discount several times, but that does not identify or define specifically what it means by that term. It's not a legal term that's typically used. That Lita never objected to the substitution of the witness, and that he noted in his recommended decision that interveners failed to provide sufficient evidence to support their position regarding CenturyLink's position on its overhead and carrying costs. No other information was provided to substantiate this claim. Lita further argued the ALJ acted as an advocate for CenturyLink when Lita offered an exhibit for admission. ALJ Garvey inquired as to whether there was any objection to its admission or if CenturyLink wanted Lita counsel to lay a foundation for its admission. Lita provides nothing further for that. I would note that these inquiries are standard practice in the PUC and other proceedings as well for objections to admission of documents. Lita also finds prejudice in the ALJ failing to take administrative notice of 4 emergency service outage reports filed in a separate M docket. As indicated previously, there were exceptions filed to the application, the recommended decision by Lita. I do not believe that that was one of the issues that it raised in its exceptions. Lita provides further cross-examination of CenturyLink's witness by the ALJ for the proposition that he was biased towards CenturyLink, and questioned the relevancy of questioning by Lita of its witness without objection by opposing counsel. Lita states that the ALJ expressed annoyance with offers of evidence and argument about evidence that did not support granting CenturyLink's application. Lita states that the ALJ's recommended decision did not fully and fairly consider the evidence and the argument in reaching a conclusion. Lita cites that the ALJ did not explain why he was, again using the word discounting, Exhibit 700, which was entitled Voice of Colorado Council of Authorities, Inc., in which 20 of Colorado's 57 911 governing bodies requested the ALJ not rush into a decision. Lita also expresses dismay that the ALJ did not address its carrying cost arguments. In its interim decision denying the motion to disqualify, ALJ Garvey explains that he found interveners failed to meet their burden to show CenturyLink's cost estimates were out of line, but rather only argued that the carrying costs and overhead costs were vague and could not be justified. The ALJ questioned why Lita did not raise these specific issues on exceptions. That's the background for now. If you don't have any questions, I'll go through to my findings and my recommendation to you.
Yeah, just one question. Were any of these concerns raised on exceptions in the prior case?
Lita did file exceptions to the recommended decision. And in those recommended decisions, in those exceptions, I should say, raised quite a few issues with regard to the recommended decision. However, none of these specific issues that it raises here were raised by Lita in its exceptions.
Okay, thank you. Yeah, I don't think we've seen a recusal request, certainly during my term, and I think the last one might have been 10 years ago. So unless you guys have questions, I think I would very much welcome a recommendation. Commissioner Gomez.
Yeah, that works for me. Thanks, Mr. Gomez.
Commissioner Plant.
Yep, same.
Yeah, if you could give us a recommendation, Mr. Gomez, that'd be great.
Okay, absolutely. After a complete review of the application proceeding, the transcripts of the hearing, and the affidavits provided by Lita in its motion to disqualify, it's my recommendation that Lita fail to show through those affidavits and arguments any bent of mind of the ALJ or favoritism towards CenturyLink that would reveal an unfair advantage to the applicant or affect Lita's due process rights in this proceeding. As to Lita's position that ALJ Garvey's recommended decision demonstrates bias and favoritism towards CenturyLink, it is well established that adverse legal rulings standing alone do not constitute grounds for claiming prejudice or bias. It is well established that a judge's ruling on a legal issue or opinions formed against a party are not bases for disqualification. Therefore, there is no basis for disqualification to the extent Lita counsel was displeased with the ALJ's rulings in the prior application case. As set out earlier, the facts alleged in a motion to disqualify must not be based on mere suspicion, speculation, conjecture, or innuendo, nor may they be statements of mere conclusions. Here, the factual allegations regarding the ALJ's conduct during the application proceeding constitute speculation and opinions of Lita's counsel, in my opinion. Therefore, there are not sufficient actual events and statements which evidence partiality or the appearance of bias or prejudice against Lita or its counsel by the ALJ. As stated by the court in a decision, to permit such allegations to form the basis of a legally sufficient motion to disqualify would be to permit any party dissatisfied with the outcome of a proceeding to file a motion to disqualify and consequently create unwarranted delay and chaos. Case law has also held that disqualification is unwarranted where counsel alleged a judge exhibited an extraordinary impatience and animosity towards party and counsel, consistently ridiculed questions asked, comments made, and objections made by counsel, and interrupted counsel's questions with objections and comments of his own. Clearly, ALJ Garvey's behavior during the hearing did not even come close to rising to this level, and any inferences that his politeness or joviality towards witnesses, I do not believe constitute a bent of mind or bias on his part. While the ALJ's questioning of CenturyLink's witness and statements to Lita counsel were pointed, they were not disrespectful and did not rise to the level of advocating for either party. Instead, the judge's questions served to aid him in his role in issuing a recommended decision. Also, the ALJ permitted full questioning by all counsel, additional redirect, and time for questions on supplemental direct testimony. I would also note that this decision by ALJ Garvey was not made in a vacuum. ALJ had the use of advisory staff in this proceeding and legal counsel as well during exceptions. Lita filed exceptions which were analyzed and recommendations offered through advisory staff and legal counsel, and the commission considered these. All of these recommendations and offers made through advisory and legal counsel staff. And in the end, the commission issued a decision in which it approved some of the exceptions filed by Lita, but denied other exceptions filed as well. So to the extent of that, Lita argues that the ALJ, this was the sole responsibility of the ALJ in issuing their recommended decision. I would note that they failed to recognize that that the ALJ has use of a full advisory staff in reaching his recommendations in his decision. The bulk of the factual allegations asserted in the motion and attendant affidavits consist of opinions, speculation, and unsubstantiated conclusions, in my opinion, which are legally insufficient to warrant disqualification. The volume of the allegations does not by itself make disqualification more appropriate. Therefore, again, it's my recommendation that the request of the full commission by Lita to find that ALJ Garvey's impartiality in this proceeding may reasonably be questioned and determine that ALJ Garvey should have disqualified himself under applicable legal standards and assign a different ALJ to this proceeding should be denied. And that's all I have.
Commissioner Goman?
Thanks, Mr. Gomez, for that detailed background. Very helpful, and I agree with your recommendation.
Commissioner Plant?
I agree as well.
As do I. It seems like one of the remedies would have been taking this up on exceptions in the prior case. So I agree with you, and that can be an ABC decision. And thank you, Mr. Gomez. Does that give you what you need?
It does, and thank you very much. I know that it took some time doing this, but I think given the import of the matter, it was warranted. So thank you very much.
I'd agree. So thank you, Mr. Gomez.
Yeah.
Let's hold the Black Hills rate case and the time of use rates public service company discussion till the end and jump to 25A-0075E. Mr. Deaver, Mr. Davis, public service company joining Markets Plus.
Good morning, commissioners. Thank you for the opportunity to speak with you this morning. Gerald Deaver of your advisory staff, along with Ron Davis. This last Friday, Public Service Company of Colorado submitted an application for a determination by the commission that the company's intent to enter into and participate in the Southwest Power Pool's Markets Plus organized wholesale electricity markets is in the public interest and is approved. Public Service further requests that its costs associated with that participation be recovered through the existing Electric Commodity Adjustment, or the ECA. The application, this is the first such application you've received under the rules 3750 through 3759 for regional electricity market participation, is accompanied and supported by the direct testimonies of two company witnesses. Under rule, the commission must issue a written decision within 150 days of this filing, which in this case would be Monday, July 14, 2025. Markets Plus will consist of three specific products: a regional day-ahead electricity market, a real-time electricity market, and a flexibility reserve product market. SPP established two phases for developing Markets Plus. Phase one was the process of designing, drafting, submitting, and gaining FERC approval for a Markets Plus tariff. The FERC recently approved the Markets Plus tariff on January 16th, 2025. Public Service estimates that its share of phase one costs will be approximately $2 million. Phase two incorporates the additional staffing, hardware, software development, and other activities that will be required by SPP to implement Markets Plus. Total SPP phase two costs will be approximately $150 million, which SPP intends to recover from market participants through an administrative fee that will be assessed on all market transactions. SPP intends to secure a loan to finance these costs and to repay the loan over the first 5 years of Markets Plus operations. The company estimates that administrative fees on its market activities will be approximately $10 million annually, and its share of Markets Plus financing costs will be approximately $4 million annually for the first 5 years of Public Services participation. The company will also be required to post its share of collateral for the SPP financing. This will consist of $2 million in cash and an $18 million standing letter of credit. As the SPP loan is repaid, the amount of that letter of credit will reduce accordingly. Because Marcus Plus will not include an installed capacity requirement product, participation in the markets will require Public Service to become a member of the Western Resource Adequacy Program, administered by the Western Power Pool. The company estimates these costs to be approximately $750,000 annually, with a one-time entry fee of $300,000. The company proposes to amortize and recover the entry fee over the first year of its market participation. Finally, Piesco estimates that integrating its own systems into the Marcus Plus markets will require between $13 and $15 million of software and IT system upgrades to align with SPP's market systems. The company proposes to develop a standalone revenue requirement for these costs through the ECA until such time as the costs are incorporated into the company's base rates. Market transactions will be incurred daily and settled weekly by SPP, and Piesco intends to return any revenues from energy sales in Marcus Plus to ratepayers at 100%. As the rules require, Piesco estimates that the retail rate impact per kilowatt hour will be approximately 1/100th of a cent. And once the loans are paid off in 5 years, Piesco estimates a likewise reduction of about 1/100th of 1 penny in retail rates. Piesco explains that after considering other market options, including California Independent System Operators' proposed extended day-ahead market, or EDAM, it has elected to go forward with Market Plus for 5 reasons. First, the company believes that Marcus Plus is the only day-ahead market that was built by and provides for primary governance by Western participants. Second, it contends that Marcus Plus provides more benefits relative to costs compared to the other markets that Public Service studied, including the EDAM. Third, the company can participate in the day-ahead real-time and flexibility reserves products in Marcus Plus without SPPs assuming operational or planning control of the company's transmission system, which would otherwise be the case were it to join a fully realized RTO. Fourth, Markets Plus is the only organized day-ahead market proposed for the West that will have a fully impartial and independent market monitor. Finally, Piesco believes that the Markets Plus greenhouse gas emissions tracking and accounting systems will be more beneficial for Colorado's emissions reduction goals. The company states that participating in Markets Plus is a positive next step in the evolution of its organized wholesale market participation. It believes that Markets Plus will provide access to expanded resources that will provide additional opportunities to acquire the energy it needs to support system reliability. Managing the company's generation and capacity resources through the markets more efficiently through market sales will increase revenues and reduce curtailments. Finally, Piesco believes that future long-term rates will be stabilized. This morning, due to the expedited nature of the proceeding contemplated in the Commission's rules for Piesco's participation in the day-ahead markets, the Commission should consider whether to establish a shortened notice intervention period. I'll pause here for your discussion, or I'm happy to take your questions. I can also provide a recommendation.
Yeah, if you could give us your recommendation, we'll come back with questions, comments, or a vote.
Certainly. Given the 150-day requirement under its rules, we believe the Commission should establish a shortened notice and intervention period for the Public Services application for participation in Marcus Plus, with intervention pleadings due by noon on March 4th, 2025, and responses to interventions due by noon on March 7th. We believe this will enable the Commission to take up the initial procedures at the March 12th CWM.
Well, thanks. I know this just came in Friday, Mr. Deaver, so appreciate you and Mr. Davis getting on our agenda and getting requests for interventions set so quickly. So that makes a ton of sense to me. I know other utilities in the West are looking to see us get this resolved. So with that, I support the shortened intervention period. Commissioner Gilman, questions, comments, concerns about?
Yeah, thanks, Mr. Deaver. And I also agree with your recommendation. Just a quick question. And I know this just came in, so you don't know yet is an acceptable answer. But does the company provide much like detail or substantiation for the estimated $13 to $15 million in software and IT upgrades? It's a little shocking to see that as the highest cost here, and just wondering how much detail is really provided there, or if we expect more detail as this transpires.
I understand and agree, and I haven't had a chance to review the portions of the testimony regarding that question. It is a large amount, and we're expecting quite a bit of detail, and also it will certainly be tested as the record is developed through the proceeding.
Okay, appreciate that. Thank you.
Even the $150 million that SPP has to spend seems like a bit of a shocking amount as well.
Commissioner Plant?
Thanks. I look forward to seeing the interveners' questions in this and to the debate around it. I agree with your recommendation.
As do I, and that can be an ABC decision setting short notice and an intervention period. Thank you, Mr. Deaver.
Thank you.
Proceeding number 24R-0192G, Mr. Sarah, Mr. Davis, triple R on our GCA rules.
Good morning, Commissioners. I'm Ron Davis of the Commission's advisory staff. Alex Cicera, Commission Counsel, and I'd like to present an application for rehearing, re-argument, or reconsideration of the Commission's decision on exceptions to the recommended decision adopting modified rules governing the gas cost adjustment, or GCA, that's used by Colorado's 4 investor-owned natural gas utilities to recover gas commodity costs. The main change to the GCA rules was the introduction of a new gas performance incentive mechanism, or GPIM, and that was adopted pursuant to Senate Bill 23-291. Public Service filed RRR to Decision C-25-0005 and asked the Commission to first revise the baseline used in its GPIM from a 3-year historical average measure to a current measure of market prices, and second, to reset the maximum penalty or incentive for the new GPIM to be a quarterly limit instead of a rolling 12-month limit. I'll turn it over to Mr. Acero to present the first request regarding the GPIM baseline, and then I'll present the second matter.
Mr. Acero.
Thank you. In the Commission's decision on exceptions, you noted that the statute directs the PUC to take into consideration both the different sizes of utilities and their ability to implement these PIMs. In light of the utilities' concerns about unintended consequences, you decided to take a slower, more deliberate approach to rolling out the GPIM by applying the historical baseline approach only to utilities with more than 500,000 customers. Public Service takes issue with that decision, arguing in its RRR that it's unfair and unlawful to apply the historic baseline just to Public Service. Specifically, it raises 4 arguments against the historic baseline. 1, that there was no notice that Public Service or any of the LDCs would be treated differently than any of the others. 2, nothing in the record supports treating Public Service differently from the other LDCs. 3, treating Public Service differently from those other LDCs is unlawfully discriminatory under 46-1061 and Mountain States v. PUC, a Supreme Court decision from 1979. And 4th, the adopted rules conflict with the GPIM statute because they do not protect customers or improve the utilities management of fuel costs. With that, I'll turn it back to you, Mr. Chair, for Commission discussion, and I will be around to answer any questions or provide recommendations if you're interested.
Yeah, so just a few comments. First, on our ability to adopt a different baseline by utility. And now I'm just quoting the statute. It says, The commission shall tailor the mechanisms to apply to different utilities based on a utility size or ability to implement the mechanisms. So for me, public service companies' larger sales volume potentially gives it more market leverage to implement alternative hedging and other mechanisms that may not be as readily available to smaller utilities, but once demonstrated could be extended. Likewise, public service has a larger sales and employee base to spread the fixed costs of developing new approaches in ways that smaller utilities may not. Given this and the cautions public service company laid out in asking us to delay implementation for a year, this approach of trying it out with a utility that is best able to implement something new seems to make sense, and then we can phase it in with other utilities as appropriate. And for over a year, we've been treating CNG differently based on its size. Finally, on the notice issue, the rules have been consistent for close to a year. Whether they apply to Atmos or Black Hills or not seems irrelevant to public service companies' notice and due process rights. So for all these reasons, I deny those components of the RRR. On the historical baseline, I just say again that Senate Bill 230291 was acted at a time when these forward-looking fuel indices were in place. And despite this, the legislation required us to, and again, I'm quoting now, establish mechanisms to align the financial incentives of an investor in an electric or gas utility with the interest of the utility's customers regarding incurred fuel costs. As we talked about a couple of weeks ago, this legislation seems like a direct response to the sustained gas price run-ups over the last 9 months of 2022. And my understanding of the frustration that motivated the legislation was that customers experienced very large and unpredictable bill increases, while the utilities were essentially held completely harmless financially during this commodity price run-up. From this perspective, the purpose of the legislation seems to mainly align utility and customer incentives. If there were large future changes in natural gas prices, like in 2022, to a modest extent, the gas utility would do better financially when customers did better, and vice versa. As such, forward-looking indices did not and would not align incentives during an event like in 2022. But the backward-looking indices do create such alignment. So I'd stick to our guns and deny the RRR requests, but curious to hear what you think, Commissioner Gilman.
Thanks, Chairman. Yeah, I agree with each of the points that you just made, and also wanted to express, to their point that they may not have any leverage or ability to influence gas prices. It's also potentially something they haven't tried before, as they were agnostic as to the complete pass-through nature of these costs. So it stands to reason that they never really had an incentive or a disincentive that would have caused them to try to apply such leverage or interact in the market in such a way. And I think our charge with Senate Bill 291 is to really try to institute a mechanism that does that, and that provides them the tools and the reasoning to try to assert such leverage and have that sort of influence in the market, because now for once they and their shareholders will have a stake in how well this goes for customers. I've expressed in the past, I think this is an inherently flawed economic transaction if one side wants to make as much money as possible and the other side doesn't really care, because they don't pay the cost, they just pass it through to someone else. And so, I'm not swayed by the idea that they have no control at all. I think that's a completely untested concept. And I think the purpose of this mechanism and of 291 is to try to get them to have a stake and try and get them to have and assert that influence to the extent that they can. And I think the size of the mechanism appropriately recognizes, yes, they might not have full control, but I think it's quite possible they have some control, and that this will be an ideal way to introduce that. So I agree with you in sticking to the historic baseline in rejecting their rationale for exceptions here.
Commissioner Plant.
Yeah, I agree as well. And, I think this is in line with, while it was a directive from the legislature, I think this is in line with this commission's real focus on trying to mitigate risk on consumers across the board. And, this is certainly an area where all of the risk has traditionally fallen on consumers. So, um, while this, it doesn't even it out or anything like that, it does spread the risk a little bit more across the various parties. And so I support your position on this.
Mr. Davis, the GPEM cap.
Sure. In its R, Public Service largely repeats the arguments it raised in exceptions to the recommended decision that set the GPIM cap at amount equal to the equity portion of a 30 basis point return on the utilities rate base, measured on a 12-month rolling basis. Public Service again asked that the 30 basis points be divided by 4 and applied as a firm cap each calendar quarter. The company tries to demonstrate in its R how the rolling off of penalties or incentives from previous quarters could result in actually incurred penalties or incentives being higher than the simple calculation of the equity portion of a 30 basis point return. And that, for Public Service, is approximately $5 million. Public Service argues that a quarterly cap set at 7.5 basis points, or about $1.25 million per quarter, will prevent quarter-over-quarter flips to have a cumulative impact exceeding the 30 basis point figure. Public Service argues that a quarterly cap allows for participation of all quarters, whereas the rolling average cap could cause certain quarters subsequent to cap levels not to accrue. As an alternative to the 7.5 basis point quarterly cap, Public Service proposes a weighted quarterly cap to address the seasonality of gas purchases and hence the seasonality of GPIM penalties or incentives. Public Service suggests that the 30 basis points could be apportioned across the 4 quarters based on purchase quantities so that the highest caps on incentives or penalties would apply in the first and fourth quarters of each year, or in other words, during the heating season months. I can offer a recommendation or turn it over to you for a discussion.
Yeah, we'd welcome a recommendation, Mr. Davis.
Sure. I think the company's presentation of the hypothetical rolling average approach may have served instead to demonstrate the adopted rules accomplish the cap the Commission intended. The NOPR proposed initially a cap set at 40 basis points applied to all rate base, and the recommended decision reduced that amount to 30 basis points of only the equity portion of rate base. The recommended decision states that this revised cap level is reasonable and that it preserves the intended alignment between the utility's financial experience to the customer's experience in paying the GCA while not unduly affecting the utility's overall financial risk. While that's my primary recommendation, if the Commission concludes that the $5 million should be a firm cap, I think the proposal for the weighted basis point approach is preferable to a uniform 7.5 basis point cap for each quarter.
I think I'm good with Mr. Davis's primary recommendation. Commissioner Gellman?
Yeah, I agree. I would stick with the annual rolling average. I think it's more rational. While, I appreciate the suggestion by the company of another way to do it, looking at apportioning by purchase quantities. Purchase quantities is not the only thing at play. There's also when the risk of price spikes and things like that apportions in the year, which would go really unaccounted for in that approach. So I think using the rolling average is a more appropriate strategy.
Commissioner Plant?
I agree.
As do I, and that can be an ABC decision denying the RRR and adopting the rules. Does that give you what you need, Mr. Davis?
Yes, it does.
Thank you, sir. 24R-0410E, public rules dealing with the ECA. Mr. Acera, Mr. Davis.
Yeah, so in a separate rulemaking to implement similar provisions in SB 291. The Commission adopted changes to its rules regulating electric utilities to address natural gas cost fuel recovery. The rules require the two investor-owned utilities in the state to file an application for the approval of an incentive mechanism, here called the EGPM, to be implemented as part of their full fuel cost recovery clause. And that's the electric commodity adjustment for Public Service Company of Colorado and the energy cost adjustment for Black Hills Colorado Electric. Public Service timely filed an application for RRR to the Commission's decision adopting the rules. The company requests that the Commission extend the requirement to file that EGPM application from within 60 days of the effective date of the rules to not later than 180 days. Public Service argues that it will need time to develop its proposed EGPM mechanism in a thoughtful and detailed manner, and that the 60-day requirement is not sufficient. For reference, if the Commission grants Public Service's request, its EGPM filing would be submitted sometime in mid-November. If the Commission denies the request, the filing would be submitted sometime around the end of June. I can provide a recommendation if you'd like.
That'd be great.
I agree with Public Service that it'd be reasonable to afford the utilities additional time to develop and file for approval their proposed EGPMs, and therefore I suggest the Commission grant the RRR.
That makes sense to me. Commissioner Gilman,
I agree.
Commissioner Plant,
I also agree.
and that can be an ABC decision granting the RRR and adopting the rules. Does that give you what you need on that one, Mr. Davis?
Yes, thank you.
Thank you. Let's jump back up to 24AL-0275E, the Black Hills Electric rate case. I think we had some unresolved issues. So, Ms. Friedman, and we still have the phase 2 decision to get through.
Morning, Commissioners. I'm Ellie Friedman of your advisory staff, and with me also today are Ian Fetters and Ron Davis of your advisory staff, along with Lindsay Dundas and Ruthie Harper of Commission Counsel. So yes, this morning we're continuing deliberations on the Black Hills Colorado Electric's Phase 1 and Phase 2 combined rate case that you started last week. In this proceeding, Black Hills is requesting, among other things, about $25 million in additional revenue requirement and modifications of its rate design. There are several Phase 1 issues that you discussed last week, but that you asked to bring back. So we'll start with those and then continue to the Phase 2 and other issues. So the first issue you asked to bring back is the LM6000. It's a 40 megawatt gas peaking plant whose cost recovery is currently through the Clean Air, Clean Jobs Act adjustment, but Black Hills is requesting that it be rolled into base rates. An additional issue with the LM6000 is whether $3.7 million that staff contends was overcollected in taxes should be returned to ratepayers. Last week, the chairman proposed that cost recovery could be rolled into base rates, but the amount would be offset by the $3.7 million amortized over 3 years. So on this issue, there are 2 decision points. First, should cost recovery of the LM6000 be rolled into base rate base as proposed by Black Hills? And should the Commission direct the company to reimburse ratepayers for taxes collected for the LM6000 that were above the 21% corporate tax rate? So I'll turn this back to you for your discussion and questions.
Thanks for the quick and incisive presentation, Ms. Friedman, greatly appreciated. So for me, the Commission never clearly ruled on the tax issue, and for any decision to put this asset in rate base, for me, I'd like to link it to that tax issue. Commissioner Gilman, I think you wanted a little more time to think about it. So any thoughts?
Yeah, thank you. No, and I think I can agree to your position here. You know, I think in reviewing this issue, there's really no requirement that we roll this into base rates, but rather kind of the idea that that would be more fair for the company and that that's how they finance the asset. And I think in considering that, it's important to consider both the fairness to the company as well as the fairness to the customers in that balance. And while I would agree it would be fair for the company to roll this into base rates, it would also be fair for the customers to ensure that any overcollection of their actual tax rate is addressed as part of that action. So I agree to your suggestion.
Commissioner Plant.
I agree as well.
Thank you both. Ms. Friedman.
All right, then. So to continue the discussion of the litigation expenses that you started last week, I'll turn this over to Mr. Davis.
Mr. Davis.
Right. So the commission sought to bring back 4 items together: the expenses for this particular rate case, a proposed litigation expense tracker, alleged over recovery of past rate case expenses, and the recovery of litigation expenses of 3 earlier specific proceedings. Last week, Chair Blank proposed to apply over recovery of the 2016 rate case expenses to offset the litigation expenses sought for the previous proceedings, and then to reject a tracker but implement a negative GRSA after the rate case expenses have been recovered. With these issues, there are 4 decision points: the amount of the recoverable expenses for this proceeding. A proposal was put forth that these costs should be set at no more than approximately $184,000 with a 4-year amortization. So that amount divided by 4 would be about $46,000 a year. Second, should the commission require Black Hills to file a negative GRSA? Or in the alternative, should the commission authorize Black Hills to create a tracker? The next decision point here is, should the commission require Black Hills to adjust its cost of service to amortize over 2 years the alleged overcollection of rate case expenses? And that amount is estimated to be about $842,000. And then fourth, should the commission allow Black Hills to recover the litigation expenses incurred in the Phase 2 rate case that followed the previous Phase 1 rate case, the company's recently concluded electric resource plan proceeding, and the cost of its inaugural distribution system plan proceeding? Those costs for the 3 proceedings are approximately $2.4 million. And if cost recovery is granted, the question is what the amortization period should be. The company has proposed a 2-year amortization. So if Chair Blank's proposal is accepted, the $2.4 million would be offset by $842,000, leaving approximately $1.56 million for recovery. If that's a 2-year amortization, that would be $780,000 per year, which is significantly more than the $46,000 that we've been talking about for the cost of the amortized annual costs for this rate case. So as you can continue your deliberations on these 4 points, we suggest that the commission consider the amortizations and the negative GRSAs in light of those financial figures.
So I think for me, I just put them all together. The old rate case over recovery, the prior case, this case, and just do it. Offset it all in one GRSA that's amortized. I think over 2 years was the request, Mr. Davis? Or was
the
it
request for the previous cases was 2-year amortization, and the company agreed to a 4-year amortization for the costs of this particular rate case.
I don't know. I'd probably just amortize it over, say, 3 years, all of it. But Commissioner Gilman, again, you wanted to think about it a little longer, wherever you'd like to go.
Yes, thank you. Yeah, I'm again supportive of the strategy here of looking at a netting, especially because I mean it's hard for me to reason in my mind that we sit here and debate over the exact rate case expenses and what, you know, consultant work or counsel work should be in or out of that if it just continues in perpetuity without any regard to if the actual expenses have been recovered or not. And clearly there was a fairly significant benefit to the company in that regard in continuing to collect an expense past when it was actually collected by not filing a rate case for such a long time in this circumstance. I also agree with Mr. Davis. It seems as though the whole discussion or debate on the negative GRSA for the current rate case expenses are just a much smaller deal than these past litigation expenses. And so it makes sense that we would certainly care about those past or other litigation expenses with regard to this accuracy check on ensuring that once those costs are recovered through the amortization period, that we go to like a negative GRSA or other strategy to ensure they're not continuing to be collected after the actual expense has already, been gained by the company. So I guess I could agree to 3 years for all of it, or we could go with the 2 and 4 respectively and go to a negative GRSA for each, which may be even more complicated, but certainly I would like to express my interest in this being an actual figure that gets collected and does not just go on for as long as the company takes to file another rate case, which would just make all of these debates and things around rate case expenses oddly irrelevant. So I wouldn't understand why we do them in the first place. So yeah, interested to hear from Commissioner Plant with regard to amortization period for each of them, but I think we agree on the main premise of the rest.
Commissioner Plant.
Yeah, I think I agree. Let's if possible, let's keep it simple, and just net out all the rate costs and assign one amortization period. I think 3 years is fine for all of them. I don't know why we would pick different amounts for different components of the rate expenses, but if we're just put them all together, net it out, and do a 3-year amortization, I mean, my understanding is that there's a statutory requirement for August 2027 for a rate case. Is that correct? So that it may be that the negative GRSA is technically not required, although with past performance, I would say let's put it in there anyway, just because in the event that doesn't get filed and we go for an extended period of time again, I think we can expect that this is what would happen. And so I think just having those that safety valve there is probably a smart move.
So Commissioner Gilman, are you all right with so no time value of money, no WACC return, no return on anything? It's just nominal dollars. It all offsets and a 3-year 3-year amortization and 1 GRSA. Does that work for you?
Yeah.
All right. Thank you, Mr. Davis. Thanks to you both. Ms. Friedman.
So turning to depreciation expense, Black Hills employs a year-end annualization of a depreciation expense in its cost of service, but UCA argues that since the company is using a 13-month average rate base, it should use a corresponding 13-month depreciation expense calculation. So the decision point is, should the commission authorize year-end annualized depreciation expense as proposed by Black Hills? And last week, Chairman Blank recommended requiring the 13-month average depreciation expense. So I'll turn the discussion back to you.
I'm still where I was last week, but Commissioner Gilman, again, I think you wanted a little more time to think about it. So to you.
Yeah, I mean, I feel like I could go either way on this. I would certainly appreciate if the timeframes match. That logically makes sense to me, but I could also see a point to use kind of the latest and most accurate figure. I think my desire here would be for us to move to more consistency across the board, so it's not kind of just gamed as to which depreciation value is higher. It's the one that always gets advocated for by the utility, but decide, if we're think matching is more important to try to pursue that in a fairly regular basis as it makes sense on records, so that we're not kind of getting these values to be cherry picked for each situation.
Well, in this case, I land with customers and want to see the lower rates. So I'm on average. But Commissioner Plant, do you have thoughts?
Yeah, I mean, I agree with Commissioner Gilman on trying to establish some sort of a consistent basis so that it's not
Ad hoc every time.
Yeah, ad hoc, well, this number's higher, so we're for that one, and this number's lower, so we're for that one. And so I think, going with the average on the basis of the matching principle is a good approach.
All right. Does that give you what you need on this one, Ms. Friedman?
Yes, I just want to confirm, Commissioner Gilman, you are agreeing with the 13-month average?
She
Yeah,
wants consistency, I think.
I always want consistency. Yeah, I mean, I think absent any really compelling reason to deviate, I would go with the matching principles so that we can really establish more consistency, so we're not kind of just having values cherry picked based on what appears more advantageous.
Okay, thank you. So the next issue is vacant positions. Staff and UCA recommend removing $1 to $1.5 million from the cost of service for 15 vacant positions the company had at the end of 2023. In rebuttal testimony, the company applied a vacancy lag calculation that resulted in a reduction in revenue requirement of $183,000. On this issue, the decision for the commission is, should you remove the vacancy expenses from the cost of service as recommended by staff and UCA, which is the $1 million to $1.5 million. Last week, Chairman Blank offered a suggestion considering that the grossing up the 15 vacant positions at the end of the HTY of 2023 up to the 26 average vacancies from 2015 to 2023, it's a gross up of about 73%. So taking that to the $183,000 that the company is recommending, it would result in an adjustment of $315,000. So I'll turn it back to you for discussion.
Yeah, again, it just seemed like Black Hills had the better way of doing it, but they were applying it to far too low a number of vacancies, but I don't feel strongly about this one. So, Commissioner Gilman?
No, I'm okay with your approach here. I appreciate the kind of added accuracy of Black Hills doing this calculation to figure out for what portion of the year. Yet it makes little sense to employ that sort of accuracy with a demonstrably below average year that you're doing the calculations for. So that doesn't really promote accuracy either. So I think that your approach really tries to remedy that issue in that, we use their methodology, which I think did make sense, but really correct it for what looks to be, a much more average circumstance. If you look at the data, the 2023 historical test year does not look much like the other years. And that's a reason to make the correction that you suggested.
Commissioner Plant?
Yeah, I agree. I support your math. So I appreciate you diving in and taking it on, and I agree with your methodology.
Yeah, to the extent it's supported by advisors. Keep going, Ms. Friedman.
The final issue brought back from last week is staff's contention that Black Hills collected some $573,000 each year for the pension and medical expenses associated with the acquisition of Aquila in 2008. So staff requests the commission require Black Hills to reimburse ratepayers some $13.5 million amortized over 3 years. And the commission's decision here is, should you require that reimbursement for the Aquila pension and retiree medical assets? So once again, I'll turn the discussion back to you.
So I'll just start and say, if we were being asked to include this expense in this cost and rates now, it would be a very easy decision for me to vote to deny that request. forcing a retroactive adjustment seems like a heavier lift. So given, the 4 other decisions, maybe I'd sort of reluctantly leave this as it is, but I think this one's tougher for me, but curious to hear what you guys think. It's a big dollar thing and probably a heavy lift to do it retroactively, but curious to see what you think, Commissioner Gilman.
Yeah, I agree with you on all points. I mean, it's hard to figure out why it's been the customer's responsibility, apparently, to make up for this underfunding that was a circumstance when they purchased the utility, and why that's not a shareholder issue. I agree with you. I think looking at 2016, perhaps a different decision could have been made, but we are where we are now, and I agree with you. It's not going to be in the forward rates. Probably what bothers me the most is I think this appears to me to be a glowing example of how kind of delay on the part of the utility to produce information that's asked has apparently resulted in success here of them getting reimbursement for an expense that I think is very questionable. The customer should have paid for. So I probably object the most to that tactic, and that tactic apparently being successful here since it was allowed in 2016, and they just haven't had a rate case since, right? So the rule was bring it forward in another rate case, and now the expense is gone and fully collected. So I think a very dissatisfying situation, but I agree with you in that I'm not really confident what can be done at this point in time, but I think does point to a little bit of a wider trend we see with several expenses here. That's kind of a ask for forgiveness rather than permission to collect some of these expenses, which I think is very much something we need to continue to look at going forward, apparently, especially with Black Hills Electric, and be very critical of those expenses, especially those of which the company did not actually ask to be in base rates, but appear there nonetheless.
Commissioner Plant, 2 very soft positions.
I gotta tell you, this is just so annoying. And I mean, the whole process of it, I think that, when they negotiated the buyout, they blew it and they just put it into the rate base, what they had miscalculated and never brought it up. And we never would have known about it, except that they looked at the 10, the interveners in the last case looked at the 10K and said, wait a minute, how come the ratepayers are picking up this? And I will note that there was one dissent from Commissioner Concilia last time in the 2016 case where she said they didn't make their case. And I have to agree. That being said, the commission made a decision at that time, and I think that their standard was maybe different than our standard, and that they asked for more clarifying information in the next case, but allowed it to continue to go forward. And as
For 8 years.
as Commissioner Gilman pointed out, they just took that ball and ran with it. And at this point, yeah, the expense is gone, and unfortunately, the ratepayers picked that up. I would be interested to know if this went into, some sort of a pension fund, what kind of returns that pension fund made over the last few years, and where the revenues from that pension fund have gone. But these are things that we just don't know, and we're not getting the information for. And at this point, I feel like we're a little hamstrung by the decision that was already made, and that the fact that these expenses are now gone. But I'm really disappointed in the actions of the company on this particular point, and you know, I feel like we're kind of hamstrung on this one.
Well, we could just you know, apply a quarter of the difference or something, or a third of the adjustment. I don't know, just to send a message. I don't know if you have any thoughts on that. It's not something I've bounced off advisors, and I do think it's a heavy lift to do this retroactively. I mean, maybe you can add it to the other rate case expenses. I don't know. Any thoughts about doing something like that? Commissioner Plant, Commissioner Gilman?
I mean, I think you're seeing through these deliberations the critical eye with which we're looking at the case that the company's brought, which in part is reflective of their past actions and past failures, it looks like, to be forthright with the commission on some of these issues. So I'm not sure there's an independent action here, which feels like a heavier lift given the past commission rulings here. But certainly all of these actions inform the commission's understanding and view of the company going forward.
All right. I guess we'll keep moving on unless you have any other advice, Commissioner Plant.
No, I think, I think our hands are somewhat tied on this one.
All right. Does that give you what you need on the phase one revenue requirement piece, Ms. Friedman?
Yes, thank you. So now we'll turn to the phase two issues, and I'll turn to Mr. Fetters to address cost allocation methodology.
Mr. Fetter.
Good morning, commissioners. I appear to be a black screen. Is that, or can y'all see and hear me okay?
Nope. We can hear you. We just can't see you. But
Okay.
You're coming through loud and clear, so keep going.
Okay. I'm Ian Fetters with y'all's advisory staff, and now we are going to begin talking about phase two issues in this case, starting with cost allocation methodology. As part of this case, Black Hills conducted a class cost of service study, or CCOS, to assign costs to customer classes. Within that CCOS, Black Hills proposes to allocate production costs using the average and excess for coincident peak method, or A&E4CP. It proposes to allocate transmission costs using the for coincident peak method, or 4CP, and distribution costs using the non-coincident peak method, or NCP. All of these were the same methods used and approved in its last phase two rate case, 17AL0477E. To give some quick background, coincident peak, or CP, refers to the hour or month of the year when the maximum system load occurs. Customer class demands are measured at the time of the maximum system load to determine the customer class coincident peak. Allocators based on coincident peak are typically used to allocate costs that coincide with the monthly system peak. 4CP specifically refers to the average of the peaks occurring in the 4 summer months of June through September. As part of this case, Black Hills performed a system load study which showed its system peak consistently occurring in those 4 months, with only those months achieving 90% or greater of the annual system peak load for the past decade. Average and excess, then, is a cost allocation methodology which combines the base load demand of all customer classes with the demand attributable to peak. The average component refers to each class's proportion of that total average system demand, and the excess component is the portion of demand for each class that is above their system average demand. In the case of A&E 4CP specifically, the excess component is determined based on the difference between the average of the customer classes for summer month coincident peaks and the class's average demands. The company says that A&E 4CP is appropriate for allocating production costs because it both assigns a base level of cost responsibility to all classes while also determining overall responsibility using summer month demand, which, quote, reflects how production costs are driven by summer load. By contrast, Black Hills is proposing to use the 4CP method to allocate transmission costs rather than A&E 4CP. The company states that, unlike generation resources, there is no trade-off between capital costs and energy costs when building transmission plant, and the same transmission line would be built to serve peak load regardless of how heavy the load is at different times. Accordingly, it does not think an average component would be appropriate. UCA disagrees with the use of A&E 4CP to allocate production costs. It contends that the A&E 4CP method is inconsistent with the NARUC manual and accepted industry practices, and calls the use of CP demands a fundamental error in Black Hill's approach. However, UCA does not propose any single methodology in its place. It instead contends that CCOSs are inherently imprecise and should only be used as a guide. To that effect, they conducted studies using 5 different methods of allocation for generation planned, and then used the average of those 5 methods to evaluate revenue responsibilities. Those methods include A&E non-coincident peak, 12CP, peak and average, base intermediate peak, and probability of dispatch. UCA also disagrees with Black Hill's use of 4CP to allocate transmission costs. It asserts that 4CP does not consider that transmission facilities are used every hour of the year, and notes that there are economies of scale associated with transmission lines, which make the relationship between cost and peak load not fully linear. In place of 4CP, UCA proposes to use the 12CP method based on the average of system peaks throughout the whole year rather than just those in the summer months, which it says would strike a balance between the use of transmission lines as a conduit for energy coming from generation plants and transmission lines' load capability. Staff does not take any issue with any of Black Hill's CCOS methodologies at this time. However, it does encourage Black Hills to consider alternative allocation methods for energy-only generating resources in the future. Staff notes that in PSCO's last rate case, 23AL0243E, PSCO presented several innovative methods for energy resources, including probability of dispatch peak hours, which was ultimately approved by the Commission. However, staff also notes that the Peak View wind facility is still being recovered through the ECA and RESA, so it does not see such methodologies as necessary for Black Hills at this time. In rebuttal, Black Hills agrees to adopt staff's recommendation to revisit the appropriateness of all allocation methods in the CCOS in its next rate case. However, it asserts that A&E 4CP for production costs and 4CP transmission costs are still the appropriate allocation methods to use in this case. It asserts that its CCOS was developed following empirically sound industry standards. The company recounts that A&E 4CP and 4CP were both approved in the company's previous rate case, and similar allocators had been used and approved in the case prior to that. Black Hills also notes that the only difference between its A&E 4CP allocator and UCA's proposed A&E NCP allocator is the excess component, which would result in a large shift of costs. It also asserts that 4CP is more appropriate for transmission cost allocation than 12CP because its system peaks in the summer months, and those classes that contribute more to system peak should be assigned greater transmission plant costs. So there are a few decision points here, and I'm just going to break them into 2 groups, one set for production and then one set for transmission. First, what allocation method should be set for production cost in this proceeding, and should the Commission require a full review of production cost allocation in Black Hill's next Phase 2 rate case? And I can pause for discussion.
If you have a recommendation, that'd be great.
Sure. Advisors recommend retaining the A&E 4CP method for production costs this time and requiring fuller analyses of production cost allocation methodology in the company's next Phase 2 rate case. A&E 4CP was approved in Black Hill's most recent case and had been used for PSCO for decades prior to its most recent Phase 2 case. Accordingly, it is an accepted practice in the state of Colorado. Advisors see flaws with several methodologies proposed by UCA in this proceeding. In particular, several of the methodologies not giving weight to the system peak, which is still inherently one of the biggest drivers of production costs. Allocators also don't see a reason at this time to deviate from what is standard practice. While Black Hill's generation system is certainly growing more complex, neither the Peak View wind facility nor Clean Energy Plan resources are included in rate base in this proceeding. Nevertheless, while certain methods of allocation may be more aligned with cost causation than others, there can be sensible arguments for and against many different allocation methodologies for a given bucket of costs. Advisors appreciate UCA proposing different allocation methodologies and note that Black Hills provided little discussion of them on the record in this proceeding. In addition, Black Hills did agree with staff's proposal to consider alternative cost methodologies in the future. Accordingly, advisors recommend A fuller discussion of Black Hill's next phase 2 proceeding, including but not limited to A&E 4CP, all of the methods proposed by UCA in this proceeding, and probability of dispatch peak hours with 1,000 peak hours as approved by the Commission for PSCO in case number 23 AL 0243E.
Commissioner Goman, we just went through this in the Public Service Company one. I continue to believe that the right answer is like 150 hours to 200 hours, or really what I like is resource by resource, depending on category of rate what's in rate base with distribution and transmission and 150 hours. But what do you think?
I'm okay with Mr. Fetter's recommendation here. While I think and agree with you, it's trending in that direction, at least currently, especially with the PQ wind facility being collected outside of base rates. There's not a compelling reason right now, especially on this record that was honestly pretty thin outside of UCA's suggestions, to change at this time. But I think the approach outlined by Mr. Fetters to require analysis of these different methodologies in the next rate case will provide us kind of an appropriate basis to really have that full analysis and discussion, especially, prior to, say, like that large wind facility rolling into base rates, which would be probably more impactful than changing the methodology with current base rates.
Commissioner Plant.
Yeah, I agree with the recommendation. The only sort of amendment I would offer is that in addition to 1,000 peak hour, there's an analysis of 100. I think we did get both of those in the accelerate case, and I think it helps us to understand the different dynamics of probability of dispatch on peak hour when we look at a couple of different ranges like that.
So I guess Mr. Fetters, in the final order, if you can just make sure we look at all the options included in the Public Service Company one for the next one, that'd be great. With that, I also support your recommendation.
Sounds good.
Move to the next one.
Yeah, on transmission costs, the decision points are similar. Which allocation method should be set in this proceeding, and should the Commission require a full review of transmission cost allocation methodology in Black Hill's next phase 2 rate case? And similarly, advisors recommend approving the 4CP method to allocate transmission costs as proposed by Black Hills in this case, but also recommend a fuller discussion of transmission cost allocation methodologies, including both 4CP and the 12CP method proposed by UCA in the next phase 2 rate case.
Along with the other methodologies we just discussed. So with that, I think I support your recommendation. Commissioner Gumman.
I also support that, and kind of on this point as well as the last one. Ideally, within the decision, we can elaborate a bit on what sort of analysis or data points they should show, just to make sure we're being properly but not overly prescriptive, so that we can actually see the pertinent data that we're actually asking for in that direct case in the next rate case.
Works for me. Commissioner Plant.
I agree.
Ms. Friedman, I think, is up next. Rate impact mitigation.
Yeah, so the class cost of service study results in a 20% increase in the residential customer rates, but Black Hills proposes to mitigate the impact of this increase, applying a 13.99% increase uniformly across all rate classes based on the company's proposed revenue requirement as it stands. Black Hills cites to principles of stability, gradualism, and predictability of rates in its rate mitigation strategy. While this proposal keeps residential rates lower, rates for large power service rate class would go from essentially no increase under the class cost of service study to a 14% increase. Staff objects to rate mitigation because staff contends customers should bear the full costs that they impose on the system. Additionally, rate mitigation mutes price signals that would encourage conservation and energy efficiency. Staff argues that mitigation shifts attention away from the increased rate request and argues that it is inappropriate to shift costs to an already struggling business community. Canyon City Florence agree with staff that rather than implementing a mitigation strategy, the Commission should closely consider all proposed cost recovery and limit the overall amount of the rate increase. Canyon City Florence recommend the Commission consider phasing in capital costs into rate base with customer rate increases occurring over time. So the decision for the Commission is whether to authorize Black Hills to employ a rate mitigation strategy by using a uniform increase across all rate classes. And I can pause for your discussion or provide a recommendation.
We'd welcome a recommendation, or at least I would.
Sure. Advisors recommend mitigating the rate increase to Black Hills residential customers through the use of a uniform increase across all rate classes. The Commission has authorized rate mitigation strategies in other rate cases, and given the concerns for affordability of rates in this proceeding, mitigating the rate increase is in the overall public interest. We acknowledge staff's arguments that customers should bear the cost of their energy load and have the opportunity to respond to price signals, but it is clear that many customers and residential customers in Black Hills service territory are struggling with their current bills, and any rate increase will likely cause efforts to minimize energy use. We also acknowledge that minimizing authorized expenses in the company's revenue requirement is let's see. I think I have a little extra in there. So we are just, that's what happens when you have a script over a couple of weeks. We recommend for those reasons that the Commission authorize a rate mitigation strategy that will apply an equal increase percent across all rate classes.
That makes sense to me. Commissioner Gilman.
Thanks, Ms. Friedman. Yeah, I think balancing the issue, it makes sense to move forward with the uniform increase in this particular circumstance, but I will acknowledge, I mean, got a lot of attention during the proceeding that they really struggle to attract businesses, and it is notable that this Black Hills proposal may make that situation a little worse because we're kind of minimizing the residential rate increase at the expense of larger customers and making their rates more expensive. And so to the extent the overall economic circumstances are difficult, this could continue to make it difficult to attract businesses. At the same time, those real serious, economic concerns affect a very great number of residential customers. So I think on balance, it makes sense in this circumstance to look at the rate mitigation, but it's not without some concerns, which I acknowledge, and there's no perfect answer here. But I think it makes sense in this circumstance, despite the drawback.
Commissioner Plant,
Yeah.
I certainly agree with that concern.
Yeah, I agree. I agree with the recommendation and also with Commissioner Gilman's comments.
So maybe you can put that discussion in the order, Ms. Friedman.
We'll do that. So
Ms.
for the next, I'm sorry.
Nope.
I'll turn it back to Mr. Fetters for the next couple of issues.
Mr. Fetters.
Hello again, commissioners. I'm now talking about inclining block rates. In this rate case, Black Hills is proposing to eliminate its inclining block structure for residential customers and replace it with a flat energy rate applied to all kWh. The company asserts that inclining block rates can be a barrier to all electric homes, and in particular, the installation of heat pumps. It also cites concerns of cost causation, fairness, equity, and ease of understanding as reasons supporting the change. Regarding equity specifically, in direct testimony, company witness Ahrens asserts that there is evidence inclining block structures may result in income qualified or IQ customers having higher bills compared under a flat energy rate. Mr. Ahrens compared meter data from customers participating in the Black Hills Energy Affordability Program, or EAP, to all residential customers and found that customers in the EAP had higher electricity usage than the average customer for all months in the H2Y. Staff supports Black Hills' proposal to eliminate its inclining block rate structure, stating that inclining block rates are not cost-based and are contrary to beneficial electrification. EOC opposes the elimination of the inclining block structure and says that the Commission should retain it as a way for customers to save on their energy bills through conservation. EOC disputes the company's analysis, saying that EAP customers are not fully representative of all income qualified customers and have price signals which make it less likely for them to restrict usage than other IQ customers. EOC observes that in the company's last rate case, EAP customers had lower usage than the average residential customer and suggests that the shift between rate cases is due to those customers' lack of price signals. EOC believes that the elimination of inclining block rates would inadvertently create an inequitable result, and also notes that the company supported the inclining block structure in its last rate case. In its rebuttal, Black Hills acknowledges that it has not done an analysis on IQ customers' usage beyond its EAP customers, but states that the evidence shows EAP customers use less than the class states that since the evidence shows EAP customers use less than the class average, the same could be true for other IQ customers. It points out that regardless, some high energy use customers would be income qualified and would be penalized under inclining block rate structures, and reiterates that inclining block rates are a disincentive to beneficial electrification. So the decision point is, should the Commission eliminate Black Hill's existing inclining block rate and replace it with a flat energy rate? And I will pause for discussion.
Yeah, so for me, I was supportive of EISC's concerns about the impact of replacing inverter block rates could have on IQ customers. And I think the inclining block rate structure is established, and it gives customers an opportunity to save on their bills through conservation. Given the impact on IQ customers, I thought EOC got the better, or at least held its own on the argument based on the statistics coming out of Black Hill's previous rate case, in which EAP customers use less electricity than the class average. I also think we can let people opt out into heat pump rates as they evolve over time. So I'm sort of intrigued by just keeping the inclining block rates, but curious to see what you guys think. Commissioner Gilman?
Under what circumstance would you keep the inclining block rate kind of as a voluntary opt-in option, or as some sort of more default option?
Yeah, just the default. It's basically keeping the status quo, right, Mr. Fetters?
That is EOC's recommendation. That's right.
I mean, I don't see enough support or really enough data to support keeping that as some sort of a default option. If you wanted to explore having it as a voluntary offering, I'm also concerned it's not really a cost reflective rate, as staff points out, which leads me more concerned. I understand if something is more beneficial, especially for IQ customers, it may make sense to have that be an optional offering, whether it's available to all customers or just a subset of customers. But to keep it as a default rate, I'm just not really seeing the rationale. But could look at
it is the status quo. It is the status quo. So Black Hills is proposing to move away from the status quo.
Yeah, and I generally agree with moving away, because I think it is more cost reflective to move away from that. However, if there's a certain subset of customers that we're concerned about still need it to be available, that's not a reason to keep it the default for everyone, but could be a reason to keep it as an optional opt-in rate if necessary.
I don't know. There's a record to do that, and I don't feel strongly about this one. Commissioner Plant?
Yeah, I think I mean, I agree with you. I think there's a number of issues that are kind of related.
Who are you talking to, Commissioner Gilman or me?
No, to you, Mr. Chairman. I disagree that inclining block rates aren't reflective of costs. I think higher energy users drive more costs. And I do think it works against beneficial electrification. I think that, you know, we're going to be deciding on a number of different things, including, you know, time of use, which I think is sort of established based on a flat rate. whether time of use is opt-in or opt-out, which sort of addresses whether or not there's a default for an inclining block rate. So a lot of these things are sort of dependent on each other. You know, I would personally prefer to keep the inclining block rate just because it does offer low energy users and I think disproportionately low income people a benefit. That's not to say that there aren't any low income people out there who maybe have you know, baseboard heating and leaky buildings and they're high energy users. I don't think you're going to find any kind of universal answer, but I think that you know, generally you have when the low income population has a lower energy use just because their you know, their energy demands aren't as big. And so I see the benefit in maintaining an inclining block rate structure, but I think that whether or not that's the default or whether it's an option kind of depends on what our decisions are on some other things.
All right, let's keep going. Mr. Fetters, if you can take us over through TOU rates, that'd be great. And I think we still have time to bring this back for one more week if we want to confirm more on this issue, but hopefully we can resolve everything else. Keep us going, Mr. Fetters.
Sounds good. Now turning to time of use rates or TOU rates. First, I'm going to give some quick background on time of use rates generally in this case before proceeding to individual issues and discrete decision points. Black Hills currently has a plethora of TOU rate tariffs available, which have been created over the course of different proceedings and have different structures and characteristics. In this case, the company is proposing to simplify its offerings and offer a consistent structure for all rate classes in hopes of reducing customer confusion and leading to greater adoption of TOU rates. Black Hills' history with TOU rates dates back to its last Phase 2 case, number 17AL-0477E. In that case, it did not propose residential TOU rates. However, several parties recommended TOU rates be established for residential customers, and ultimately the Commission found a TOU program should be developed and ordered Black Hills to file a residential TOU application by October 1st, 2018. However, when the company filed an opt-out residential TOU pilot program, the Commission ended up rejecting the program. In case number 20A-0195E, Black Hills First Transportation Electrification Program, or TEP, the company filed to create residential TOU rates for customers who have electric vehicles. Although the rate was created in the context of the TEP, the rate was ultimately made available for all residential customers on an opt-in basis. The most recent EV TOU rate for commercial customers was established in case number 23A-0025E. So starting with price ratio, Black Hills is proposing a 2-to-1 price ratio for all of its TOU rates and classes. The company's current TOU rates have price ratios that vary by class and season. For instance, the residential serviced EV rate has a 3-to-1 ratio in summer months and a 2-to-1 ratio in non-summer months, while the large general service secondary EV non-demand rate has a 1.2-to-1 ratio for all months. Black Hills is particularly concerned that residential customers see the 3-to-1 ratio in the summer as punitive and believe a 2-to-1 ratio would achieve greater adoption as well as simplicity, and the 2-to-1 price ratio is not opposed by any party in this case. So the decision point there is which price ratio should be used for Black Hills TOU rates, and I can pause for discussion or proceed to a recommendation.
You can give us a recommendation quickly, that'd be great.
Advisors recommend approving a 2-to-1 price ratio for all Black Hills TOU rates and classes. The ratio is not opposed by any party and has the benefit of consistency and balancing goals of price signals and customer acceptance.
That should make you happy, Commissioner Gilman. That works for me.
Yeah, I think it's generally reasonable. I mean, this could get a bit wrapped up in the question of if the time of use is opt-in or opt-out, right? With regard to how aggressive a price ratio and the time periods and all that. So I don't mean to make this conversation more complicated. But it stands to reason that some of these decisions might in part be related to the decision with regard to if this is an opt-in or an opt-out rate.
Uh, uh, with that caveat that we may have to bring it back, Commissioner Plant.
Yeah, so I have some complicated thoughts about this.
This deliberation or the next one?
Well, yeah, both actually. I'm glad you brought that up, just as a foreshadowing. Yeah, just to lay it out there, and I agree, Commissioner Gillen. I think a lot of this determination depends on a variety of different things around how we structure the time of use and the opt-in, opt-out. And just to lay my cards on the table, I view this time of use as something that we should structure to try and make it fit within people's lives. And I think that our tendency is to look just at the load curves and say, okay, here's the highest, 4 hours. Here's the highest 5 hours. We're going to make that the time of use rate. And I don't think that really is considering sort of how that impacts people's lives and what their choices are. And I think that maybe that is one of the reasons that people have a really negative reaction to time of use rates. I think if, you say, our peak hours are the entire time that you're home from work before you go to bed, we're not giving people an opportunity to use time of use rates the way that they're supposed to be used, which is to shift demand. And all we do is end up making people mad because they just see us increasing their rates. And so my preferred approach with the time of use is to, at least certainly at the beginning, to limit it to 2 hours. To the peak, 2 hours. It's not, let's face it, this is not our only solution around trying to mitigate peaks and modify, load curves. It's one mechanism that we have. It's an economic trigger that's designed to try and get people to act a certain way. And I think that we need to give them enough room to be able to fit it into their lives so that they have an option of maybe doing their laundry at a certain time and instead of at another time, and not take up the entire time that they're home with their family. So I think that, in the larger picture of looking at how we structure time of uses, I would lean towards a higher price ratio with a smaller time period. And whether or not that's, an opt-in or opt-out, obviously opt-out is going to have a lot more impact. And I'm open to a discussion around that with you guys, but that's kind of where I come out on a time of use. I really think we need to limit the times that it's applied, or it's just going to be seen as a rate increase, and it's not going to fit into people's lives.
Are you open to doing more like 3 hours? I mean, not to, it's properly noticed as the next agenda item, so we can I think talk about it. But I had come on into more of that deliberation with a 4 hour block, 5 to 9 or 6 to 10. I think 2 hours is too short. Are you open to more like a 3 hour block? A 6 to 9 and we'll turn it over to Commissioner Gilman, who can effectively resolve our differences. But
Yeah.
I mean, and I guess it's less of a worry for Black Hills because they don't need massive new capital investment. So I'm maybe okay for 2 hours here. But when you look at, Excel's capital budget, it 2 hours is just not enough for the demand that's driving the capital. So if you just, and sorry, Mr. Fetters, this was a conversation. It's just all integrated, so we just might as well have the conversation.
There's lots of TOU today.
Yeah, maybe we'll see. We may defer the later TOU till next week, but and any thoughts on that, and then I'll quickly turn it over to you, Commissioner Goman.
Yeah, I'm really I think that 2 hours is really the limit. I think we can ask people to defer energy use when they're only home for a certain, few hours. And I just feel like we need to err on the side of trying to fit within people's lives in order to have an effective program.
I'm way more sympathetic to that argument for Black Hills than I am for public service, and we don't have to resolve public service in this discussion. But Commissioner Goodman, anywhere you'd like to go on any case? On any of these two cases,
Leave it wide open.
Properly noticed until council boots in.
At first blush, and really this the first I'm hearing of it, especially because I think no party advocates for a 2-hour window in this proceeding.
In either case.
In either case. I'd be very concerned about a 2-hour window and a high price differential. All that does is pushes the usage to either side, which are marginally also peak time. And so I think you have the effect of kind of squishing the usage out to the hour immediately before and the hour immediately after, which just makes a new peak. I think we should be clearly considerate of people's lives and abilities to react and try to design things to understand how it interacts, obviously, with the end customer. But I think our core goal here as economic regulators of the energy system is to properly and transparently show the customers the actual economics of the system and the actual economic choices that need to be made. At the end of the day, I view time of use rates as a tool to minimize and optimize overall system costs. And if we don't accurately choose the peak period, or if we, through poor design, cause new peaks that cause more investment, more system build out, the end result is higher costs for customers. Kind of across the board. And to me, that's the main purpose of time of use is to send an accurate price signal to those customers so that they can be part of aiding us in reducing overall system costs. It is not to be punitive. It's not to provide customers with few options, but it is to really accurately show them what's going on. I don't think we're doing any service to customers if we don't accurately portray those costs, because at the end of the day, if we get it wrong and then customer behavior just causes the system to continue to peak at certain times, which yes, will be in the evening hours. Like that is the undisputed fact here. This peak is going to end up in the evening hours. Then I think we end up with longer term higher costs for everyone, which doesn't serve the customers well in the end. Although, it may feel more quote unquote fair because we're not picking the hours that are more expensive, but we're not picking the hours that are more expensive, right? That is when it literally is more expensive. And we're trying to provide that transparency and tool to customers to be part of that, to reduce that usage on the total system. So, I don't know. I mean, the direction I'm thinking here, like bigger picture with Black Hills specifically, I was envisioning we would likely move to a flat rate as the default option for residential customers. I think hearing the chair's concerns, I'm not generally opposed to allowing an inverted block rate to remain an option as an opt-in for customers who see that as more preferential, although I think the data on what is better for income qualified customers is very shaky. We've got one analysis showing they use more and one analysis showing they use less. So I don't think there's any obvious conclusion that can be drawn from the data in this record. But allowing it as an option for those income qualified customers who may see that as benefit, Okay, I don't really see any harm in that. And then allowing time of use as another opt-in option at this time. I agree with the prior commission in saying we would like to move there. We would like a full analysis of that because I think in the end that is a path to reducing overall system costs. But there are so many communication and trust challenges here between the utility and its customers. I think just communicating this rate change alone will be a really heavy lift. We don't need to complicate it. Probably by making time of use the default here, although I do agree with the premise that would be an ideal place to aim and to continue going. So I would probably say we go with a flat rate as the default. You could allow these two both as voluntary opt-in options that are designed to allow customers to get on them and benefit if they're able to participate.
Mr. Fetters, is it workable to do inverter block rates as an option? Does that create revenue neutrality issues, or we don't know? Is there anybody on this record who's asking for that?
I don't believe anybody on this record is proposing for inclining block rates to be an optional rate. I think either of the rates in a vacuum can be and have been revenue neutral. And so having it as an option inherently doesn't break any sort of revenue neutrality rules. But there could be some concerns with incentives and sort of gaming the system, knowing what your load is and then choosing for that optional rate. But that is kind of inherently a concern with these sorts of optional rates.
All right, let me throw out a proposal. Just listening to this discussion and let you guys play around with it and do what you want. So we'll keep flat rates. We'll keep an option for inclining block rates. We'll keep a 2-to-1 price ratio. Maybe we'll narrow the peak demand period from say 5 to 8 and keep the time of use rates opt in. What do you guys and I mean, I'm just trying to pull together what I heard from both of you. I don't know. It's just like trying to articulate a middle ground. So maybe I'll start with you, Commissioner Gilman, modify that any way you wish, and then I'll turn it over to Commissioner Plant. And I suspect it may make none of us happy, but maybe we find a nice middle ground. And I don't know that I would not want to land here with public service. I feel very differently about that situation. But for this situation, what do you think of that, Commissioner Gilman?
The default residential rate is flat rate. There's an option for an inclining block rate, and then there's an optional opt-in time of use rate as well. And you're saying time of use rate would be a 2-to-1 price ratio and a 5 to 8 peak.
Yeah, and I think we'd have to in a technical conference, Black Hills may need to adjust it to make sure it's revenue neutral. But that's what I'm suggesting.
Yeah, I'm fairly concerned with the 4 to 5 hour. That's when the 2023 peak was, and we would be excluding it, knowingly excluding it. So I'm a little concerned about that, but happy to hear from Commissioner Plant.
Yeah, I mean, I just think as we add solar to the system, 4 to 5 is not going to be anywhere close to our highest loss of load probability.
I think that's possible. Increasingly obvious a lot of the data we've seen across proceedings, but I will say too, with the time of use as an opt-in option, right? Some of those concerns about flexibility and look, I think it would be ideal as a policy objective to see a good amount of customer opt-in to the program, right? We don't want it to be unattractive, yet I don't think it carries the same exact concern as an opt-out program or a default program, where it can be kind of more widely viewed as punitive. You would get people in the time of use who are able to react and go toward it. So less worried about a longer period, especially as an opt-in, and that customers would be selecting this rate voluntarily. Unless
So
about
just to frame it up for Commissioner Plant, your modification to my proposal would be to extend it to more like a 4-hour block from 4 to 8. I can guess how Commissioner Plant is going to respond, but
I think that's preferable based on the record here. I think there's quite a bit of concern about the 4 to 5 p.m. hour based on what we're seeing. I agree with your premise that will probably decline over time as we add more and more solar to the system. But it is the primary peak at this point in time, which makes it a little difficult to ignore.
I guess we could also postpone it after 2025, after the summer of 2025. So it wouldn't get implemented till the summer of 2026. But go ahead. Sorry, Commissioner Plant.
Yeah, you're just adding to the part that I don't like. But I have, so what about there's the flat rate, which is just same price all hours, regardless of how much you use. What if we had a flat rate that was inclining block, basically? So you know, your inclining block rate is a flat rate, but it's based on, you know, if you fall in this block, you know, your consumption in that block is going to be at this rate, your consumption in this block is going to be at that rate, your consumption at this block is going to be at different rates. So you've got basically 3 different flat rates based on what block you fall into, and then have an opt-in, you know, which obviously, you know, works against beneficial electrification, but as an opt-in, you could go into the time of use rate.
I don't think we have that on the record, do we, Mr. Fetters? All we have is the current inverted block structure, which, you know, applies to each customer month. So as you use more, you get into the higher block. Am I right about that? I think you'd be
That's right.
designing a new rate with no evidence, you know, no party behind it and no evidence about revenue neutrality. So you want to just get, I mean, so your preference would be to keep the inclining block rate. So why don't you just take my proposal and make it into the
so I'd
Commissioner
say
Plant proposal, including going through towards inclining block rates, if that's what you want.
Yeah, I'd say do the inclining block rate as the default, and then provide a TOU as an option, and just as a giveaway to Commissioner Gilman, I'd support her amendment, even though I don't really like long TOUs.
All right. So you would prefer an inclining block rate with an opt-in TOU.
And the 2 to 1.
2 to 1 ratio. And do you have a peak demand period?
Oh, I was saying, you know, that if that were the situation, then I could accept Commissioner Gilman's extension to 4.
So 4 to 8.
Yeah.
All right. So now the proposal on the table in front of us is maintain the inclining block structure, shift to an optional time of use rate, opt-in 2 to 1 ratio, 4 to 8. It sounds like you don't like the inclining block piece of it, Commissioner Gilman, but the rest of it's okay.
The rest of it's okay. I'm not going to get on board with the inclining block rate as the default rate. I don't see it as cost reflective as staff advocates, as well as Black Hills advocates, and I see it as contrary to beneficial electrification policy objectives. So I'm not going to get on board with the inclining block rate as any sort of default.
I think I'm with you, Commissioner Plant. So you may be looking at a dissent on that inclining block rate. and we can, I'm happy to try and bring this back next week, if as needed. So I think, Mr. Fetters, that resolves, issues 9, 10, 11, and 12. And, let me ask you this, are you guys ready to do, the public service company time of use rates today, or do you need to delay them into next, week? Because if we want to do that today, I think we take a break now. And maybe we should take a break anyway, but let's just help structure our morning. Commissioner Gilman, are you prepared to do time of use rates for a public service company today?
I think we take a break anyway.
Yeah.
And
All right.
then also, it sounds to me very much like we should start that discussion today, and I really doubt the conversation will end today. But I think it might be important to hear where you're all at, so that we can go back
I
and
think we may have already.
I already heard where I'm at.
All right, let's take
So-
go ahead.
Sorry, I do have one very, very quick final issue on the Black Hills time of use. And that question is whether or not to require interval usage data be provided in a future filing. EOC asked for it either at 15 or 60-minute intervals, specifically by zip code, to better inform broader DOU implementation. And my recommendation is to require the company provide that interval usage data in the next proceeding in which TOU rates are at issue.
I'm good with that. Commissioner Gilman,
yes.
Commissioner Plant.
Yes, I agree. And one additional point, Mr. Chairman, I was going to 4 o'clock just to get Commissioner Gilman on board, but since you didn't get on board, I'm fine going back to 5.
All right, I'm fine. I don't like the 4 to 5 hour. And we'll implement. Are you okay implementing it in the summer of 2026 so we can get the education and see what happens with all the solar and.
Yeah.
All right. So I think we're down to 5 to 8. Getting worse for you, Commissioner Gilman. Sorry. Why don't we take a break till 11:30, and we'll come back with number 13, lucky number 13 fixed charge rate. Mr. Fetters, does that work for you?
Sounds good.
All right. 11:30. Thanks. All right, Mr. Fetters, if you can keep us moving, fixed charge.
Sure. Just a couple quick questions to clarify the time view stuff. Is there anything we would you had talked some about potentially bringing some of it back next week. Is there anything we would still be
I think we got to a vote.
okay? Commissioner Gilman, would you like to write a dissent on those couple of the inclining block rate or the uh peak hours?
I expect I will. Thanks.
Okay. And just to 100% confirm what we landed on, we've got inclining block rate as the default, and opt-in time of use with a 2-to-1 ratio, a 5 to 8 p.m. peak hour, and not implemented until summer of 2026.
Yeah, or after summer of 2025 is the way I'd say it.
Okay. Then I will go ahead and continue on the fixed charge or the customer charge. Black Hills is proposing an increase in its fixed monthly customer charge for several of its classes. It says that the increases are based on its C costs, but also reflect revenue mitigation. Black Hills also updated its proposed customer charges to reflect the results of its rebuttal cost of service study. The proposed monthly charge for standard residential customers is $9 a month, an increase of 23 cents from the current monthly charge of $8.77 a month. Staff does not oppose Black Hill's recommended customer charges in this case. However, UCA recommends that the current customer charges be maintained for the residential and small general service classes. In fact, UCA produced an analysis which it uses to claim that fixed monthly charges should be substantially lower than Black Hill's current customer charges in the range of $5 a month for residential customers. UCA contends that allocated overhead costs are inappropriate to include in the calculation of customer charges, and instead those charges should be limited to direct costs required to connect and maintain a customer's account. However, rather than recommending these substantially lower customer charges, UCA still recommends maintaining the current charges in the interest of gradualism and rate continuity. In rebuttal, Black Hills continues to support its proposed customer charges, calling them just, reasonable, and grounded in cost causation in the resultant C costs. The company disagrees with UCA's exclusion of allocated costs in the customer charges and asserts that including them follows plant and cost causation principles. Black Hills also points out that the allocation used in this case generally follows what was approved in the company's last two rate cases, with few exceptions that were specifically made to bring the allocations more in line with cost causation. So the decision point is, should the commission approve Black Hill's proposed customer charges or maintain their existing customer charges? And I could pause for discussion or have a recommendation.
Yeah, if you can make a recommendation, that'd be great.
Advisors recommend maintaining Black Hill's currently existing customer charges. We do support the company's methodology for calculating the customer charges proposed in this proceeding, including an allocated share of overhead costs, and agree it is consistent with methodologies used in past proceedings. However, maintaining the currently existing customer charges is in the interest of rate stability as well as affordability for low usage customers. And further, considering the reductions to the company's cost of service made within these deliberations, a C cost model that reflects this decision would likely produce lower customer charges than those the company is currently proposing.
Commissioner Goman,
I agree.
Commissioner Plant,
I also agree.
as do I.
Thank you, commissioners. I'll now turn it back to Ms. Friedman for medical exemption program.
Thank you, Mr. Fetters. Yeah, so we have one more issue in the phase 2 set. Colorado statute requires utilities with inclining block rate plans to provide a medical exemption rate for customers who have heat-sensitive medical conditions or who rely on essential life support device and are unable to reduce electric usage during summer months. So with the move from the proposed IBR, the Black Hills proposed, they had also proposed eliminating that medical exemption rate. I'm assuming now that since the commissioners have voted to maintain the IBR rate, this is not an issue. So I think we, if that's consistent with your understanding of what your rate design would be.
I think that's right. Do you guys see it any different? No, I think we can keep
Right.
going.
So essentially, Black Hills, even though they had eliminated it when they proposed the flat rate, they would just maintain the IBR, the MEP rate that is consistent with their current IBR.
All right.
All right, then. So now there are several issues raised by other parties in this proceeding. So I'll go back to Mr. Fetters, who can address the heat pump rate proposed.
Hello again. I'm now going to be talking about heat pump rates. In this case, Western Resource Advocates and Sierra Club, jointly WRASC, filed answer testimony encouraging the Commission require Black Hills to provide a heat pump rate, noting that Senate Bill 24214 requires such voluntary rate be filed on or before August 1st, 2027. WRASC proposed two heat pump rates, both seasonally differentiated, one with a flat rate in the summer and the other with a time of use rate in the summer. They argue that although the company has until August 2027 to file a heat pump rate pursuant to SB 24214, this proceeding would offer a chance to begin educating customers on heat pump rates, encourage heat pump adoption in advance of the state's 2030 clean heat target, and could be an appropriate venue to establish heat pump rate design. In rebuttals, Black Hills contends that its optional residential TOU rates proposed in this case meet the requirements of Senate Bill 24214. They state that heat pump customers can preheat their homes prior to on-peak time, similarly to air conditioning, and doing so could result in cost savings for heat pump customers. Staff also filed cross-answer testimony recommending that WRASC's heat pump rates be rejected. Staff expresses concerns that boutique rates, or rates offered only to some customers within a rate class, inherently do not reflect cost causation. Staff is also concerned about having limited time to review the rate since it was first introduced in answer testimony, and has a number of specific concerns to the rate proposed by WRASC, including concerns around revenue neutrality, the possibility of customers gaming the rate, and the rate not being developed using the full CCOS process. So there are three decision points on heat pump rates, which I'll just list here. The first is, should the Commission approve WRASC's proposed heat pump rates in this proceeding? Second is, should the Commission find that Black Hills TOU rates meet the heat pump rate requirement of SB 24214? And the final is, should the Commission make any other heat pump rate orders in this proceeding? And I can pause for discussion and can provide a recommendation.
If you could give us a recommendation, that'd be great.
Advisors do not recommend approving WRASC's proposed heat pump rates in this case. Under SB 24214, the company is not required to propose a heat pump rate until as late as August 2027. Advisors also agree with several staff's critiques of WRASC's proposed rates, including the development of the rates outside of the scope of the CCOS and the rates not being revenue neutral, and that other rate design proposals in this case can potentially offer heat pump customers limited relief. At the same time, advisors agree with WRASC that the company's TOU rate is not sufficient for the requirements of SB 24214. The residential TOU rate, giving heat pump customers an opportunity to save money by changing their usage behavior, is no different than for any other residential customers, and WRASC have presented evidence that heat pump customers would actually pay more on average under the company's TOU rates than their standard rate, which the company did not dispute. Accordingly, advisors recommend that the Commission reiterate the filing requirement and deadlines found in SB 24214, direct the company to invite all interested stakeholders, including the parties in this proceeding, to participate in the stakeholder process at least 60 days before filing a heat pump rate, provide accompanying analysis showing that first, the proposed rate will reduce heat pump customer bills if just cost justified while being revenue neutral for the entire class. Second, whether the rate should be limited to only heat pump customers or available to all residential customers when they make the filing, and encourage consideration of seasonally differentiated rates as part of this analysis.
Commissioner Gilman.
Thanks, Mr. Fetters. Yeah, I generally agree with your recommendations here. I'm not sure we have the record to move forward here, but agree with you and WRA that the time of use rates are not sufficient to comply, and that we'll need another rate filing prior to August 1st, 2027 to actually have a heat pump rate in effect. You know, one of the things I found the most kind of confusing and troubling, and especially going through the evidentiary hearing, was hearing the company kind of repeatedly talk about this denominator problem. They don't sell enough kilowatt hours to spread their costs over enough, so the rates are high. And they seem to kind of singularly see one solution to this, which is to pursue new EDR legislation, as they put it in the evidentiary hearing, which is fine. They can pursue whatever legislation they'd like, but that would just be targeted at essentially getting new, very large customers and providing them a discount to join the system. And it's a little baffling to me why the company doesn't see other load growth opportunities as kind of getting at this denominator problem, one of which certainly would be increased adoption and encouragement of beneficial electrification in their service territory. Clearly, one of the struggles there is that their rates are higher than many of the neighboring utilities, and beneficial electrification could struggle there more. They also have, overwhelmingly a summer peak, and increasing winter sales across their system just looks to be something that could really benefit them in addressing this denominator problem. So I'm honestly a little confused why they're not more interested in seeing more heat pumps adopted and really in earnest pursuing a heat pump rate as they're directed to by legislation that would further encourage this and provide, I think, cost justified decreases in bills to those customers who really increase and improve their capacity factor year round and provide those additional sales, which can provide downward rate pressure in total. So I agree with your conclusions there that they will need to file again before August 2027 in order to have a compliant heat pump rate. And I appreciate a lot of staff's concerns here with a boutique rate. I personally don't 100% care if this is something that's only for if you have a heat pump, that there might be a bit more drama to that than it's worth in policing what actual heating equipment individual customers have. But I generally see different seasonally differentiated and high differential time of use rates to be pretty ideal paths to consider in advantaging in a cost-based way this sort of year-round higher usage through beneficial electrification. So look forward to a stakeholder process and then an additional filing where we can get and adjudicate a compliant rate for the heat pump requirement moving forward.
So I also support your recommendation and support including Commissioner Gilman's comments in the order. Commissioner Plant?
Yeah, I agree, and I agree with Commissioner Gilman's comments, and I think that it's a good point that it's not just heat pumps, it's capacity, but then it's also just not capacity, it's flexible capacity, and that I think there is a real there's a real need for Black Hills to develop a rate structure that reflects those benefits and entices those types of loads to be added to the system. I think it benefits the ratepayers, and it provides a utility benefit that could be used to mitigate some of these increasing costs that are being placed on ratepayers.
Does that give you what you need on heat pump issues, Mr. Fetters?
I believe it does. Thank you.
Ms. Friedman, Peakview Wind Facility.
Okay, so staff raises a concern about the company applying a return on the deferred tax asset, that's the DTA, associated with Peakview Wind Facility, which is a 60 megawatt company-owned generation facility. The settlement agreement in the facility CPCN precludes inclusion of Peakview in base rates through 2026. Black Hills collects avoided costs of Peakview through the ECA and TCA within incremental costs above avoided costs charged to the RESA. Staff's concern is that although Peakview generates production tax credits, the PTCs, whose value has been included in the revenue requirement, the PTCs have not actually been used. And this has led to a DTA of $39.6 million. The DTA was not contemplated when the CPCN settlement agreement was signed, so it was not part of the revenue requirement or as part of the prudency cost test established in the settlement agreement. Additionally, though the company did not seek commission authorization on a return on the DTA, beginning in 2018, the company has applied a WAC return to on the DTA revenue requirement included in recovery in the ECA and the RISA. Staff estimates that the amount to be some $9.6 million collected. Black Hills has indicated that it has begun transferring PTCs, but staff estimates that ratepayers will pay some $13 million in carrying costs until the DTA is extinguished. Staff recommends that as part of the company's compliance filing in this proceeding, the company should be required to update its RISA accounting to remove the DTA and any associated earnings, reducing the ECA RISA annual revenue requirement by more than $2 million. An additional $13 million would be made available to the RISA over the remaining life of the DTA. Black Hills responds that this is not the appropriate venue to examine peak view because there are no costs associated with peak view in this proceeding, and suggests that the company's annual res compliance report or the annual ECA prudency review are the places for the DTA issue to be addressed. Additionally, Black Hills states that in early 2026, they will file to extend or modify cost recovery for peak view, and staff can raise some of its concerns at that time. I also note that Black Hills 2024 ECA PCCA proceeding, which is 24A0371E, is now before an administrative law judge, and staff raises these issues in their answer testimony in that proceeding. So the question for you is, should the company be required to update its RISA accounting to remove the DTA and any associated earnings, reducing the ECA RISA annual revenue requirement by more than $2 million? I can make a recommendation or turn this to your discussion.
No. So I do have some thoughts on this. Given how badly this project has performed, given its cost to customers, given Black Hills' inability to fully monetize the tax credits for years, and given that Black Hills put this WAC return on the deferred tax asset in the ECA without asking for PUC approval, I think it's inappropriate to allow Black Hills to continue to earn a WAC return on the DTA. I get that these earnings are in the ECA and not in base rates, and also in a dispute in another case before an ALJ. Nevertheless, this is a combined phase 1 and phase 2 rate case here, implementing rates that ultimately include recovery of ECA-related costs. Moreover, the record on this issue has been appropriately developed in staff answer testimony, the company rebuttal testimony, and in oral testimony and cross-examination at hearing. So to the extent we can provide guidance to the ALJ and the other proceeding, I'd like to do that in this proceeding with implementation occur as soon as reasonably feasible. So I'm not trying to address it in the compliance order in this case, but I'd like to resolve the policy issue as I think it's really clear and inappropriate what Black Hills has been doing. And it's just really frustrating to see how poorly this plant has performed against expectations and as exacerbated by their inability to monetize the PTC. So that's where I'm at on this one. I don't know, Commissioner Gilman, your thoughts?
Yeah, thanks for that. And I get that this is somewhat complicated since there's an ECA prudency review ongoing. But I landed in a very similar place to you. I can't see my way to thinking this is a fair outcome or treatment for ratepayers at this point in time. And I think we've seen other examples where kicking things to a different proceeding or not addressing fully the actual issue has led to a recovery that could be inappropriate. So I agree with you, Chairman.
Yeah, and this one doesn't even have any commit, on the Aquila pension, there was a commission order allowing it. There's no order here. They just did it. So I think this one can, go all the way back. Commissioner Plant?
Yeah, I agree with your recommendation, Mr. Chairman.
Does that give you what you need on this one, Ms. Friedman?
Yes, thank you. So the next issue is Pueblo 5 and 6. Staff and Pueblo both raised the issue of Pueblo 5 and 6. It's retired coal-fired units that were granted decommissioning by the Commission in 2015. Black Hills states that environmental remediation was completed in January 2016, and the facility has been removed from the company's books. However, during the course of this proceeding, Black Hills found that some of the land, which is shared with the company's administrative offices, a substation, tool machine shop, and equipment laydown yard, should be removed from rate base, and accordingly removed about $71,000 from rate base in the company's rebuttal revenue requirement. The company notes that demolition of the building has been delayed because the structure has been declared an historic landmark. Staff objects to security costs associated with the site and recommends the Commission deny half of these costs and deny any property tax expense, which staff states it's unable to calculate. Black Hills argues that the security costs are necessary for its active buildings and employees on site. Pueblo contends that Black Hills has declined to provide information about contamination at the site, so the site cannot be sold or redeveloped. Pueblo witnesses suggest that the company should sell the site to the city of Pueblo for $1. Staff states the company should donate the property to the city. So the decision for the Commission is whether $40,572 of security for the area should be disallowed in this case for cost recovery. And in this issue, advisors recommend the Commission reject staff's suggestion to disallow those amounts because security is necessary. We agree that other company facilities on the site are important to ensure safety of the company's employees. Further, the issue of historic designation redevelopment of the site is not within the scope of this rate case, and so advisors recommend the commissioners do not address that issue.
That's good by me. Commissioner Gilman,
I agree.
Commissioner Plant.
Sorry, Ms. Friedman. Is there any indication when these security costs will go on in perpetuity while there's some facilities still operating on the site?
I would, the implication is that since there's there's some buildings and active site there that the company's using, they would incur the security costs for the length of the time that they're using that.
Thanks.
Commissioner Plant.
I agree.
Customer bill format.
So during the hearing, Commissioner Plant had questions about the company's bill format. Black Hills states that it redesigned its bill on proceeding number 18M0072E, and the company offers to restructure the glossary of terms page to align with rates listed in the bill and to identify the components of the 4 categories of charges in the bill: delivery and distribution, energy supply, other costs, and taxes. Since the company would be working with only Black Hills Colorado electric bills and not the billing format used across all of the Black Hills companies, it says these changes could be easily made. The company suggests it could work on the bill format update with staff as it did in the 2018 proceeding. So advisors recommend that the Commission direct Black Hills to work with staff to make the indicated changes to the customer bill.
Commissioner Plant, does that get you what you need and wanted, or would you like to go in a different direction?
Yeah, no, I appreciate that, and I agree with the recommendation.
Commissioner Gutman.
I also agree.
As do I.
So in this proceeding, staff raised questions about Black Hills Quality of Service Plan, their QSP. Prior to the evidentiary hearing, staff filed a notice of withdrawal of testimony addressing QSP issues and attached a stipulation reached between staff and Black Hills regarding a QSP. On December 3rd, 2024, Black Hills filed a motion for approval of the stipulation with trial staff regarding a quality of service plan. Advisors recommend the Commission grant the motion for approval of the QSP stipulation in this proceeding.
Commissioner Billman.
I agree. And I would also say this is an important item to be followed up on, especially given many of the concerns and complaints about service quality in the service territory.
I agree with that request, Commissioner Plant.
I also agree.
Next, in answer testimony, staff and EOC raised the issue of the wait list for Black Hills Energy Assistance Program, BHEAP, with EOC providing the latest count of 140 customers on the list as of September 2024. During the evidentiary hearing, in response to Commissioner Gilman's questions, Black Hills witness Harrington stated that it would take about $140,000 in additional BHEAP funds to include these customers on the wait list in the BHEAP program. He suggested that the $140,000 could come from the Commission's modifying of the BHEAP program cost recovery cap, or that the company could raise the funding rates from other customers. He also noted the company itself recently contributed $450,000 to the fund. Black Hills is currently collecting from non-BHEAP customers the $1 maximum allowed under statute. Under Commission Rule 3412 G2B. In its SOP, EOC suggests granting Black Hills a temporary variance of the dollar cost recovery cap under that rule, which is allowed under Rule 1003A. Although raising the $1 BHEAP cost recovery cap would affect other customers who might also be struggling with affordability, raising the cap would assist the customers who are in greatest need right now. So the decision for the Commission here is whether to require Black Hills to file an advice letter proposing changes to the tariff in order to bring the BHEAP wait list to zero. That it was required that they file an advice letter rather than just waiving that particular rule. So advisors recommend the Commission direct Black Hills to make a filing to make changes to the tariff to bring the BHEAP wait list to zero, to make that filing within 60 days of a final decision in this proceeding with an accompanying variance motion.
Commissioner Gellman,
I agree.
Commissioner Plant,
I also agree.
as do I.
Okay. Staff also raises concerns, and those are echoed by Pueblo, about the availability of Black Hills administrative offices in Pueblo, specifically that the building is open and the customers are able to pay bills inside the office. Staff raises a further concern about receipt of cash payments containing that cash and credit card payments received by third parties are subject to service charges. So in order to address this, staff recommends the Commission direct Black Hills to modify tariff sheet R14 at 9A to include this requirement, quote, the company shall accept payment at its Pueblo office during normal business hours, and the date of arrival at the Black Hills, Colorado Electric office shall be deemed the payment date. So the advisors recommend that the Commission direct Black Hills to modify its tariff as staff recommends.
That makes a lot of sense to me. Commissioner Gellman.
Just clarifying question, Ms. Friedman, is it tariff sheet R14 or R15?
I believe it's R15 section. There's a 0.9A. Are you seeing a different
that's
one?
fine. I think you said R14.
You said 14.
So I just wanted to make sure
I can't be trusted.
on the same page. No
It
worries.
is sheet R15, which it says right there at 9A.
No worries. I agree with your
Thank you.
I agree.
Commissioner Plant,
I agree.
as do I. We're paying attention, Ms. Friedman.
I know, I'm glad you are. Apparently I'm not. All right. So staff recommends modifying Black Hills tariff requiring data for at least 10 years or since the last rate reviews, because staff contends it's consistent with Commission policy, but Black Hills did not respond to some discovery requests because the company's data retention policy only requires the retention of data back to 2019. So advisors recommend that the Commission direct that Black Hills to modify its tariff to reflect that data is retained for 10 years or since the company's last rate review.
Makes sense to me. Commissioner Gellman.
I agree.
Commissioner Plant.
I also agree.
So with that, I'm going to turn the discussion to Mr. Davis to discuss the DSMCA and net metering.
Mr.
Right.
Davis.
Hi again. Black Hills recovers the cost of its demand-side management programs through the demand-side management cost adjustment, or DSMCA. And that's basically a percentage of the customer's bill. Staff voices concern that if base rates increase substantially in this case, the resulting increase in DSMCA collections could be in excess of the Commission-approved DSM funding. So staff recommends a recalculation of the appropriate percentage of the DSMCA rider in order to maintain the funding at the right level. Black Hills does not object to this proposal, but it also offers other ways to address the issue. That could be to include the effect of the new base rates in the company's April 1st filing, which will be in effect in July, for example. I recommend that the commission agree with staff and direct Black Hills to refile sheet number 71 of its DSMCA in accordance with the changes in the projected sales revenue resulting from the final decision in this case.
Commissioner Goman,
I agree.
Commissioner Plant,
I also agree.
as do I.
Now I'll turn to net metering. Net metering is implemented by Black Hills largely pursuant to its Renewable Energy Standard Compliance Plan. The company's latest RES plan covers 2023 through 2026 and was filed with Black Hills' 2022 Electric Resource Plan that included a clean energy plan. The RES plan was approved in the Commission's Phase 1 ERP decision. The RES plan was modified by an approved unanimous comprehensive settlement. The RES plan addresses net metering, where the customer receives an incentive from Black Hills in exchange for the renewable energy credits that are generated by the distributed energy resources, as well as net metering only customers where there's no incentive paid and no exchange of the RECs. Black Hills reports in its testimony in this case that at the end of 2023, it had about 7,700 residential net metered customers. The company provides what it calls an informational cost of service that the company uses to illustrate the impact of net metering. Specifically, Black Hills estimates that in 2023, it, quote, lost some $3.5 million in fixed cost recovery from customers who switched to net metering. COSA-SIA intervened in this proceeding, objecting to the informational cost of service, and recommended that the Commission require the company to present only one cost of service in future rate cases that includes the residential customer class as a single class of customers. Additionally, COSA-SIA recommends that the Commission disregard any testimony regarding alleged cost shifts due to net metering. COSA-SIA filed a motion to strike or dismiss Black Hills' testimony related to the net metering issue. The Commission denied that motion earlier in this proceeding, stating that it instead would find it beneficial to consider the whole of the information provided, given the magnitude of the requested increase in base rate revenues at issue in this case. The Commission further stated it will evaluate relevant evidence related to net metering and assign it their appropriate weight. Now, notwithstanding its presentation in this rate case, the only relief that Black Hills seems to seek from the Commission at this time, and this is as set forth in the company's closing statement of position, is for the Commission to open a miscellaneous proceeding to explore potential alternatives to the current net metering billing arrangement. So that is the decision point. Should the Commission open a miscellaneous proceeding to explore potential alternatives to the current net metering billing arrangements as requested by the company?
Well, maybe I'll jump in. I generally share Black Hill's concern about the rate impact from behind the meter standalone solar as we continue to build more utility scale solar in Colorado. I'm concerned that the primary system impact of the distributed solar is to curtail utility scale solar. But I don't know that an M docket is the place to take this up. And a lot of this, I'm told by counsel, is statutory. So given everything going on, I'm not really eager to fight this battle in an M docket. So I probably would deny, I would probably express our sympathy with rate impact concern, but not try and take this up in an M docket. So I don't know, Commissioner Gilman, where are you coming from?
Yeah, I can probably get on board with that, although soften the language a bit. I think a broader analysis would be necessary to make any determination, which we don't really have here on this record. So I think we can sympathize that they have concerns, although not really acknowledge the conclusions of those, because I don't think we have a fulsome analysis here in order to make that determination. I will note, there was a broader, more kind of statewide effort going on last year looking at net metering. So I agree with you. I don't think an M docket here is the place to address this. A lot of this is statutory and likely not a good use of our time, given that there are other efforts underway, and we don't have any sort of power to change the statutes. I'll also point out, I mean, net metering and customers adopting solar in order to save themselves on bills is often a natural consequence of high rate. And that's what we have here. So it's not surprising that we see Black Hills Electric customers increasingly going toward net metering and on-site solar, because they really are looking for relief from these rates. And that's not a bad thing. That's not a nefarious action. I mean, they're taking a logical step to try and save themselves money on what are some of the highest rates in the state. And I think that's not an incredibly unexpected outcome to the rates that we see in Black Hills Electric. So I agree with you, Chairman.
Commissioner Plant.
Yeah, I agree. I mean, I think it was maybe 8-10 years ago that the chair of the Hawaii Commission called their increase in solar a postcard from the future based on their high electricity rates. And it was a message to the rest of the country that as your rates go up, that's going to be one of the impacts. I'd add, though, that I don't think the company filing didn't offer any substantive analysis of costs and benefits of solar to the distribution systems that would provide any real guidance. Furthermore, I think they failed to provide, as was pointed out by COSOCIA, any evidence at all to support their claim that the cost of service provided to a non-solar generating customer was materially different than that provided to a solar generating customer. So I don't think that we could take their claims really at face value, because I just don't think that they provided a sufficient analysis.
Well, Mr. Davis, I don't know that gives you a single coherent viewpoint to put in the order, but I think we can work out the differences on TPC. So hopefully that gives you what. Thank you.
Thank you.
Yeah, there's some, Ms. Friedman, I think there's some uncontested items. You just want to mention them.
Yes.
And
I was just going to go through. Advisors recommend the commission authorize Black Hills to roll the TCA and the PCCA costs into base rates and set the balance for those riders at zero. That you approve the customer allowances, construction allowance as proposed by Black Hills in this proceeding. That you approve the depreciation rates proposed by Black Hills in this proceeding, and that you allow their request for vegetation management as proposed in this proceeding.
that works for me. Commissioner Gilman.
I agree on each count. Thank you.
Commissioner Plant.
I agree as well.
Thank you, Ms. Friedman. Quality of service plan. Did we already do that?
I think we did address that, and they will. That will be filed. Or the motion was approved that they'll do that. We have we have an issue that doesn't have a decision point. If the commissioners want to address that at this point, it is that in testimony and SOPs, Pueblo requests the commission establish a process through which Black Hills could be sold. Pueblo also raised this issue with Black Hills witnesses during the evidentiary hearing. Black Hills maintains in its response during hearing and its SOP that it is not looking to sell to another utility. As again, there's no decision point required here, but if the commissioners want to address this as it was raised during the hearing, now I guess would be the time to do that.
Yeah, I just have a brief comment I'd like to make. Given this record, I do think there's evidence of problems that could support Pueblo's position that these communities may be better off with a corporate sale to a new entity. If such a purchasing entity had access to a larger transmission system, greater scale, and a more disciplined approach to capital spending, it could perhaps reset the relationship with a community and attract new customers with lower starting rates. At the same time, I'm concerned we lack the authority here to order a sale, even if it was shown to be in the public interest. So for now, I think we're limited to making findings, expressing our concerns, which I'd like to do, and then leave it to the political system or markets to move that potential option forward. So Commissioner Gilman, would you be okay with language like that in our final order?
Yeah, I mean, I'd like to see the exact language. I think part of what I find very troubling is this, I think very clearly negative relationship between the company and the communities it serves and its customers. And I don't know how you remedy that, especially as the company kind of anticipates, as I understand it from the hearing, continuing to increase capital spending, which has one result, continues to increase rates for customers. I mean, they, as evidenced in the hearing, they essentially overpaid above book value by a healthy margin for the company and its assets. And, when asked if that impacts their financial positions, that, well, no, because there's lots of opportunity to keep investing, which has the outcome of raising rates. I mean, that's what it does. So, I'm worried. Look, as is often the issue in the utilities we regulate, their motive is to continue to increase investment, to increase shareholder value, which goes contrary to the ratepayers' best interest. Does that work better with a different corporate entity in charge? I don't know. I don't know. It's kind of one of the main tenets of the situation. Can we move in earnest towards a better system for customers where we're basing it much more on the quality of their service and things rather than just rate base? I think that's a question moving forward. Do we have mechanisms to move much more toward performance-based regulation, especially in this space? It's a real struggle because the utilities have much more of the underlying data and baselines than we do or than any of the parties do. But this is probably the most apparent example of that being a real problem, of the utilities having a real incentive to continue to invest, despite it likely being contrary to the best interest of the ratepayers.
I have some comments along those lines and a couple of specific recommendations, or suggestions for you to consider, although they don't get to the performance-based regulation. But I guess, Commissioner Plant, before we get to capital spending, which we'll do next, just wanted to see if you had any thoughts on the corporate sale, or with a suggestion to put some language in the order, but not try and open up and an M docket or try and extend the boundaries or push the boundaries of our authority.
Yeah, I mean, I share your perspective, Mr. Chairman, on what exactly we have the authority to do, and but I do have to say that it's really disheartening, particularly when we were down in Pueblo and in Canyon City, the number of people who came up and just said, please let us out of this, relationship, and it's it is a toxic relationship between the company and their customers. I mean, usually in a public setting like that, you'll get at least one person who, is there to say that things are going great. But we got nothing like that. And, I think that was reflected, I brought up during the hearing, the J.D. Power customer satisfaction ratings for Black Hills Energy is consistently at the bottom nationally. I mean, they just have a very bad relationship with their customers. I think that we've seen examples where there's been a disregard for how the way that they're treating their cost recovery is going to impact their customers. you know, I can completely understand the customer feelings that are reflected both in that JD Power survey as well as the comments that we received at the public hearing.
Yeah, I appreciate you ending the deliberation in the same way I tried to start it off, referencing back to the public comments, and you called it toxic. You know, just how damaged this relationship is, and struggling with the path forward. I just have a couple comments that I'd like to talk with you, following up on your direct point about the capital spending, Commissioner Gilman. And I just want to put some numbers on it. From 2016 to 2021, Black Hills capital spending averaged roughly 35 million per year. I think, Ms. Kunkel, you have an exhibit that shows that. And for me, it's that disciplined capital spending that enabled Black Hills to keep rates constant for many years. But if you look at 2022, the capital spending went over 60 million. And by 2023, it's over 90 million. And by 2024, they're proposing close to 100 million. And to me, that increased capital spending seems to be the single biggest driver of the rate increase request, and expanded rate base by over 60%. And on this record, for me, it's not entirely clear what's driving the capital spending, although affordability doesn't seem to be critical. Based on, and you can take this down now, Ms. Kunkel, based on hearing exhibit 1500, the Black Hills Corporation November 2024 investor presentation and the discussion with Mr. Harrington, I'm even more concerned about future capital spending. I think Black Hills is committed to the financial community to spend $400 to $500 million through 2028 in Colorado, continuing these high capital spending levels, which would increase rate base by another 60%. Based on this math, I'm really concerned we're going to be seeing another large rate increase soon. If we want to keep rates stable, I think we'd likely have to limit capital spending to something like depreciation escalated by inflation and revenue growth. Since depreciation in 2023 was roughly $35 million a year, to keep rate growth at inflation might imply capital spending closer to historical levels, maybe around 40 million a year, and not the 90 to $100 million a year Black Hills is currently spending and is proposing to continue to spend. So given all this, I'd like to lay out these affordability and rate impact concerns in our order. I'd like to also ask both the company and trial staff to present a rate forecast that helps us better understand the relationship between depreciation, capital spending, revenue growth, and rate impact in both the upcoming DSP and TCA Rule 32.6 filings, including what level of capital spending would be required to keep rates growing no faster than inflation. I'd also like to ask the company to present a 5-year transmission capital spending plan in its Rule 3206 filing, expected in April. Overall, I'd like to understand how much capital can be spent without raising rates above inflation. Said another way, I'm wondering if we should stop trying to set capital budgets in ad hoc proceedings with little or no understanding of the long-term rate impact, and instead set the long-term rate impact we want, and then let the company manage overall capital spending accordingly. You know, it's a big shift in regulatory approach, but given this utility, given its financial incentives, and the apparent lack of capital spending discipline, I don't know how else to get at this. So I think this is I obviously share the exact same concerns you raised, Commissioner Gilman, and this is my attempt to try and get a handle on it, because I think we're going to be right back here looking at another double-digit rate increase, or a concern that we'll be looking at a double-digit rate increase if collectively this community can't get a handle on the capital spending. So comments, thoughts?
Yeah. I agree. Look, the capital spending is the root of the problem here, and the incentives of the company are completely at odds with its customer base, which they more or less laid out in the hearing. If the right answer is to set that escalation kind of ahead of time at the rate of inflation, I'm not sure. I don't know what sections of their system are aging out. I mean, one thing that would kind of exacerbate all of the problems is if they're not able to make necessary repairs for quality service and lead to worse service conditions in the area. If they really suffer on reliability or something like that, that could only serve potentially to make the situation worse locally, so I'm trying to figure out how do we really logically understand what is the optimization of the spending. I don't know if there is some predetermined limit of the spending, but you want to be sure that every dollar spent is really absolutely necessary and is going toward improving the service and reliability for the people receiving this service. So, I mean, it seems, especially given the real difficulty in where the company sees incentives here and what customers need, I'd be more inclined to say that some sort of more broad shift to performance-based regulation would be ideal, so that we're basing it more on outcomes rather than some predetermined math on how much they could spend every year. But the devil's in the details on all of that, right? I mean, we have standalone PIMs and performance-based regulation, but moving more wholesale to that approach is very difficult because we require a ton of data, primarily from the company, to ensure that we're setting the baselines appropriately and really targeting the right things to ensure we're providing the right incentives. In the long term, ideally, I see that as a better remedy to this problem, but I will acknowledge that there's some lead time to getting that to happen, and it's easier said than done. So I don't know. I don't know if setting an inflation is a choice that could backfire with.
Yeah, all right, put that aside. I think the short-term request is to have them as part of the DSP and the next Rule 3206 filing, just tell us what the capital budget is and what that means for rate impacts. And then we can do what we wish with the data. So that's the real request.
I think that's reasonable. And would it include, I mean, it seems necessary in looking at rate impacts that it would include some forecasts as to capacity and sales in the coming years. Yeah, I mean, because as part of that, I've already expressed this, but I would feel a lot better if the company had a broader, better strategy to increasing sales than to just give very large customers a discount. It would be a lot more heartening if they were looking at more options, looking much more creatively across the board at ways to do so, at ways to improve the capacity factor of the system, increase off-peak sales, and really encourage that sort of behavior to decrease the rates for everyone, rather than seeing a singular tool that to me probably really misses the point and does not serve the customers well. So perhaps that could be part of the analysis, as well as just a more fulsome investigation discussion into how to raise off-peak system sales.
That makes sense to me. Commissioner or Plan, anything you'd like to add?
Yeah, no, I think it's I mean, I appreciate you bringing the idea forward because I think it's definitely worth thinking about. And it's not, I mean, it is a real divergence from our, sort of the way things have been done in the past, but I don't know that it's necessarily a divergence from the way most people do things. I mean, generally you have a budget.
Yeah, right.
I don't think that's really getting too outlandish there. You know, and there may be a way in which, you know, I think that Commissioner Gilman's concerns are very valid. And, you know, there may be a way that we can structure something like this where there is a very, very strong incentive for the utility to plan within a budget, and that there is a disincentive for exceeding it. And I'm not sure if those are, you know, based on, you know, regulatory lag, or those are based on, you know, the time and effort needed to get things approved, or what exactly that disincentive and incentive are. But I think that, you know, looking at the trend that you put up there, Mr. Chairman, and I appreciate you bringing attention to that, you know, there's a real significant possibility that we are continuing to come in with rate case after rate case that is a continual increase in the rates to customers, and that far exceed inflation. And that is, I'll just point out, very, very much a change from the past. If anything, utility rates have traditionally been well below the rate of inflation and have lagged other commodities in the economy in increases. And I think we're seeing indications, or the first indications here, that that's changing.
All right, well, I'll give council and advisors some language, and we can work, see what we can do on the TBC process. I have one more issue to raise with my colleagues, Ms. Friedman, and then I'll turn it back to you on the technical conference. One last thing, like our decision in the Public Service Company gas rate case, I view our decisions here as a balancing exercise that results in an outcome where the whole doesn't always necessarily reflect the sum of the parts. For example, if one piece of our decision from today is altered, say on appeals to the courts on remand, I may vote to adjust another component to maintain the overall balance. As such, I view our decision in this case as a tapestry where pulling on any individual thread should not necessarily be allowed to unwind the integrated nature of the balance. And I just ask that council put this type of language and concept in our final order, like we did in the Public Service Company gas rate case. Commissioner Gilman, would you be all right with that?
I am. Thanks.
Commissioner Plant?
I am as well.
Thank you. Ms. Friedman, I think we're going to schedule a technical conference.
Right. With the issues that you've discussed and made decisions on in this proceeding, we recommend that you schedule a technical conference for March 3rd, 2025, to be overseen by an administrative law judge, and it would be held remotely via Zoom. And we would recommend that you direct Black Hills to file an updated cost of service study, accompanying class cost allocated cost of service study, base rate summary and bill impact analysis, and DSMCA recalculation. And those should be filed no later than February 28th, 2025.
I strongly support that recommendation, and would just say my spreadsheet shows a total revenue deficiency that is roughly at the amounts proposed by UCA in its answer testimony. And I think the advisor spreadsheet lands in a similar place, but I'm not confident that I did all the calculations correctly, and just think we need to see the company's view of the rate impact and all the other elements Ms. Friedman outlined before we finalize our order. So Commissioner Gilman, are you okay with the technical conference as Ms. Friedman outlines?
I am. Thank you.
Commissioner Plant?
I am as well.
All
I
right.
assume that can be a TBC order directing the technical conference?
No,
I mean, ABC.
so Yeah,
ABC.
so I do this as two separate orders. If we could do a TBC order in the rate case, the full rate case order, I think that'll take some time, but I think we got till mid to end of March. And then if you can do an ABC order scheduling the technical conference, that'd be great.
Yes, thank you.
Does that give you everything you need on this item, Ms. Friedman?
So I think we're set.
All right. And it sounds like we don't have to come back next week. I guess you guys, do you want to try and take another break and grab some lunch, or do you want to keep pounding through the time of use rates for public service?
Trying to decide. I presume, Mr. Davis, maybe what would work for today is to have like a fairly high level discussion on where we're at, and especially probably on the decision point on implementation timeline to kind of guide our discussion and see if it's best to have a high level conversation today and then bring this back.
It's up to you. I'm prepared to resolve the whole thing. So if you need more time, we can just limit it to a high level conversation. So whatever you'd like. I mean, for me, I don't think I'm interested in trying to do this before implement rates before the summer of 2025. I think it's too soon. But what's your thinking?
I'm not sure how close we are to resolving it today, given some of the prior discussions. So I don't know how confident to be. Maybe we take like a 20-minute break so we could eat some reasonable amount of food for lunch and then come back and see how far we get.
Okay. Mr. Davis, does that work with you and your schedule?
Yes, that will be fine. We can take a break, and then I'll start off a discussion and get some guidance from you on how you'd like to proceed after the break.
Cool. All right, let's break till 1 p.m. and we'll come back at 1. Thanks. Mr. Davis, all right, let me just find the docket number. Proceeding number 24AL-0377E, Public Service Companies time of use rate case, time of use case.
Great. The final case for today's business meeting involves the time of use rates implemented by Xcel Energy, or what we at the PUC call Public Service Company of Colorado. The Commission required Public Service to file an update to its time of use rates last September to allow for new rates for residential customers and small commercial customers to be in effect by May 1st of this year. And that's the start of the next summer air conditioning season. That means that this case was administered on a faster than normal schedule. The Commission conducted its formal hearing in January, and closing statements of position were just filed 3 weeks ago. And as you know, when time of use rates take effect remains a key decision point in this case. Public Service states that a minimum period of 4 months from a final Commission decision is needed to put the updated rates into effect. 4 months is necessary to complete the associated billing and internal software changes, and will also promote the company's ability to commence its communication and engagement strategy. Staff of the Commission recommends that the time of use rate change be delayed until after the summer cooling season in order to encourage effective customer education efforts. And according to staff, effective implementation requires Public Service to have sufficient time to develop a plan and educational materials that reflect the outcome of this proceeding. Staff also argues that implementing new time of use rates outside of the summer season will provide an opportunity for customers to familiarize themselves with the new rates and adapt their usage without the seasonal impacts that stem from hot summer weather. Western Resource Advocates agrees with staff that the new time of use rate should not be changed until after summer 2025. WRA actually recommends that the Commission direct Public Service to launch its revised time of use rates by March 1st of next year. This delayed timeline would allow the company to better develop its communication and education. Furthermore, according to WRA, the delay will ensure that customers are familiar with the new rate periods before the resource mix of Public Service's electric utility system begins to substantially change in 2026 due to the implementation of its clean energy plan. Energy Outreach Colorado likewise agrees, arguing that the record supports not revising the time of use rates until at least after summer 2025 in October at the earliest. EOC suggests that the Commission allow at least 4 months from a final Commission decision to launch any revised time of use rate to allow time for the company's stated minimum education and communications. The City of Boulder states that if the Commission approves any changes to the residential time of use rates, implementation should be delayed until after summer 2025 for at least 2 reasons. First, Public Service states that it's not possible to implement the rates prior to July. And second, delayed implementation would allow for new rate designs to reflect the resource acquisition that will incur in the upcoming just transition solicitation. Boulder also states that a rate comparison tool must be available to customers prior to the effective date of any time of use rate changes that are approved in this proceeding. And finally, the Colorado Renewable Energy Society recommends a delay in the implementation of a revised residential time of use until October 2025. I raise these points on timing because it may make sense for a full discussion about if and how to modify the rates to be postponed until next month, including a final vote on implementation. However, it also may make sense for the commissioners to talk about their ideas today and to resume those discussions later next month. If we could first talk about how you'd like to proceed. I can present a case overview, or that can wait, and the Commission can discuss initial thoughts today.
So I guess first I'm fine delaying implementation for at least 6 months till October, consistent with the company staff, WRA, EOC, and others. But I think it is worth laying out our positions today, just so we know where each other is coming. I did not see the 2-hour peak demand period headed our way, so I think we better. Yeah, go ahead.
I'm just trying to keep our relationship interesting.
You're succeeding, but you didn't have to worry. So that would be my preference to just start going through it now, and I'm prepared to, depending on where you guys are coming from, vote or delay to next week. So, Commissioner Gilman, what do you think?
Yeah, I think with regard to timing specifically, I take staff's point and that of some other parties that it could be counterproductive to implement the rates in the middle of the summer, the peak cooling season, especially given what the company's laid out for a timeline, which is probably a bit longer than I would have expected to actually get them implemented after the conclusion here, which would put us right in the middle of the cooling season. It's quite possible that could lead to a rush in the education and consumer understanding, and also potentially be a setback in customers understanding how the rate actually impacts them, in that if it's implemented right in the middle of the peak cooling season when a lot of customers' usage is the highest, that could lead them to really not quite understand what is leading their bill to be higher, as it might just actually be increased usage. And then we might actually get kind of a more negative reaction just due to some misunderstanding. So I take those points well. I think the initial push here was really in trying to be as accurate and transparent as possible with customers about when we actually see that peak occurring and when we see that peak occurring in the future. And since time of use is fairly new to a lot of customers, really balancing we don't want to change it right away, but we also don't want to prolong how long we're training customers on a rate we already know is out of date. And so I think that was the original balancing act that led us to want to see it sooner than later. But I think the points made in this proceeding were compelling. I would certainly prefer if it was significantly in advance of next summer to avoid this issue. So I think the October target that was brought up is the most reasonable to me. But that being said, I don't think we're in a huge rush today to resolve this today. I know we have a pretty packed agenda next week too. So I would just suggest we take the opportunity today to hear high level where each other are. I agree. I've heard some surprises already, so I want to make sure I understand and am prepared to really debate the final outcomes of this, likely in early to mid-March, whenever we can bring it back. So, but I think introducing the issues and at least getting initial reactions will be beneficial to me in being able to come to a conclusion in just one more meeting.
Commissioner Plant, any more surprises for us?
No, I agree. I mean, we pushed up the timing of this because we wanted to get it in place by this summer, and no mention was made of the 4 months after a decision at that time that it was going to take to get it in place. And then it turns out that really there weren't any interveners that wanted to do it anyway. So yeah, I agree with trying to get it in place, early enough to get some communication and education out to customers to be able to be effective in the next heating season.
All right. So it looks like I think I think we could view it almost as a vote to start no sooner than October 1st, but well before next summer's cooling season. So you want to get us going, Mr. Davis?
Okay, well, would you like a traditional overview of the case presentation, or shall I focus on some specific issues to tee up discussion about your individual thoughts?
Yeah, maybe the latter, given that we're like 4 hours into this already today.
Okay. Why don't I start with revenue neutrality then?
I think that's good.
Okay. So revenue neutrality means that this rate filing is not expected to have an effect on public services annual revenues collected from residential customers or small commercial customers. And that's because the proposed rates are designed in a way that they would generate the same revenues as approved by the commission in the company's last base rate proceeding. That doesn't mean that there aren't going to be different bill impacts for different types of customers, but the way these rates are designed, it's so that they do not generate more revenues. Now, staff recommends that the commission adopt a time of use rate design that is revenue neutral compared to the rate it replaces. That means that regardless of the time of use periods or price ratio, and we'll talk about those concepts later, the rate should collect the same commission-approved revenue requirement from each class of ratepayers as established for those rate classes previously. Staff argues that it's essential that the proposed changes in rate design be revenue neutral to maintain consistency with the Commission's previous approval of the revenue requirement and customer class allocations. But more importantly, staff argues that revenue neutrality should be central to the Commission's understanding of the bill impacts associated with the outcome of this proceeding. Revenue neutrality means that the bill impacts are on average zero, and any bill impacts associated with the changes in time of use rate depend entirely on whether the customer's electricity consumption occurs disproportionately on peak or off peak compared to an average ratepayer. Public Service agrees that the Commission should approve a revenue neutral rate as just and reasonable. The company states that over 95% of customers are expected to have monthly bill impacts of the range of a reduction of $5.40 to an increase of about $4. But again, the intent is that the average bill impact will be zero. Kroger, the grocer, agrees with Public Service that it's more beneficial for customers to achieve a moderate reduction to their loads across all peak hours that drive system costs rather than achieving more significant load reductions during certain peak hours while increasing loads during other peak hours. And again, this ties to the notion of revenue neutrality. So the first topic for you to discuss is, should the Commission maintain revenue neutrality when establishing the rates in this proceeding?
So for me, I just say revenue neutrality is an absolute core principle, and I would require that it be maintained. I'd also make as clear as we can in our order and discussion that the purpose of these modified TOU rates is to help manage down system capital needs, and that for most customers, this will have positive or no rate impact. And as you say, it's just clearly not intended as a bill increase. And I'd also emphasize that we're approving an opt-out structure to those customers who like to opt out to do so. So, the purpose is to provide an opportunity for customers who can change their behavior in ways that benefit the system to do so and lower their rates. So I have some general opening comments, but I'll wait until the other issues are framed up before making them. So Commissioner Gilman on revenue neutrality.
Yeah, and I think we would be best served in this conversation and as the company communicates any rates as an outcome here to maybe use some layman's terms as far as what revenue neutrality means, which I think Mr. Davis laid out, but I think it's helpful to continue to emphasize, this is not a rate intended to make the company any more or any less money. I know several of the public comments have kind of alluded to that, and I think it's important to emphasize that the analysis within this proceeding and done by the consumer advocates and people paying attention it is intended to hit this point that whatever is allowed for a collection of total money from the company is still that number. There's just a bit of a reapportionment to ensure we're sending an accurate price signal to customers based on when the system is peaking and when the system is legitimately more expensive to use, with the end goal to reduce the overall cost of build out of the system as we continue into the future. So I agree with you, Chairman, that revenue neutrality or keeping that overall rate picture such that it is not intended to make the company any more or less money, but to result in the same outcome for them. And on average, the same outcome for customers is an important tenet here that I would emphasize as you did.
Yeah, thanks for helping us put it in plainer and simpler language and moving away from the jargon. Commissioner Plant.
Yeah, I agree.
All right, Mr. Davis.
So what I propose now to do is talk about two topics that are interrelated, and I think this will get to the main question before you this afternoon. One part of that is what modifications should be made, if any, to the time of use periods. And then I think also before you have that discussion, maybe it would make sense for me to present the proposals regarding what's called a super off-peak period.
Yeah.
So that everyone can follow. Time of use rates mean that the price of electricity changes depending on when electricity is being used. And typically, rates are applied for an on-peak period and an off-peak period. And there can be seasonal differences in those periods due to different daylight hours or outdoor temperatures. They're intended to more accurately reflect the actual cost of operating the system. And it's during on-peak hours when systems tend to be under the greatest strain and the costs and risks are the highest. But rates can be lowered in the future if consumers reduce their electricity use at those peak times. And when utilities can reduce their costs, the result can be savings for ratepayers. The current on-peak period is 3 to 7 p.m. And when setting an on-peak period, the Commission has considered at least two measures of system strain, cost, and risk. And the first in this proceeding has been called gross load, or that in general terms means all the electricity customers are wanting to use at a point in time. And the second concept that's been used, the second metric for establishing an on-peak period, has been what's called net load. And that's the gross load that I just described, less what is being produced from renewable generation. The Commission required that Public Service file this case to update its time of use periods in consideration of the amount of renewable generation being added to the system in the future years, especially since the current TOU rates were developed a few years ago. And so this discussion about whether to change on-peak periods really is another review of system strain, costs, and risks. And that's why I think this case is before you now. And while the on-peak period is when the system is most strained and the costs and risks are the highest, it's easy to think about the off-peak period being just the opposite. But some of the parties in this case are asking the Commission to not just consider one type of off-peak period. Instead, they ask the Commission to carve out from that off-peak period certain hours when renewable energy production is so high that the costs of making electricity approach or are at zero. And that's what is called in this proceeding a super off-peak period. And so with that, let's turn to the positions of the parties here on the proposed new peak periods. Public Service recommends that the Commission approve an on-peak rate period from 4 p.m. to 9 p.m. in the summer and 5 p.m. to 9 p.m. in the winter. The company argues that these periods best meet the Commission's goal of maximizing beneficial load shift to support future reductions in the system's new generation needs. Public Service explains that the hours from 7 p.m. to 10 p.m. represent the majority of the top 100 net load hours in the summer of 2031, while the gross load peak is expected to occur in the 5 to 6 p.m. hour. In 2025, this year, the summer hours of 4 p.m. to 9 p.m. represent the highest net load hours. And for winter, Public Service explains that the 5 p.m. to 9 p.m. period represents the majority of the top 100 net load hours in the winter of 2031, and it's also a good match for the current system. If the Commission seeks a year-round alternative to an on-peak period, it asserts that a year-round period from 5 p.m. to 9 p.m. is the second best option. Public Service opposes a shortened peak period, such as one from 6 p.m. to 9 p.m., because it will be insufficient to shift load away from the hours that will drive generation capacity needs and other near-term system costs. Staff of the Commission recommends that the company's time of use rates be modified to eliminate shoulder periods and establish a year-round on-peak period from 5 p.m. to 10 p.m. on non-holiday weekdays. Staff further recommends that the 5 to 10 p.m. period should be the default on-peak period for all of the company's residential and commercial rates. Staff states that the 5 to 10 p.m. window will remain the appropriate on-peak period for at least the next 6 years. Staff suggests that consistent on-peak periods will greatly improve customer acceptance of time of use rates and will reduce challenges and expenses that come with customer education. Staff recommends that the Commission disregard proposals to maintain the time of use rate periods as they are now. Staff argues that those current rates fail to align with the fundamental directive for this proceeding to identify the appropriate periods based on changes in load and generation that have already occurred since the time of use rates were initially established and that are forecasted to continue in the years ahead. Echoing its position regarding the need for time of rates to be revenue neutral, staff notes that even if ratepayers do not modify their usage patterns, approximately 75% of customers will see no change or even a bill decrease under staff's rate proposals. Staff warns the Commission not to adopt a 3-hour on-peak window because that would fail to adequately account for the full range of hours during which the company's forecasted peak load may occur. Staff's analysis reveals that the precise peak load hours vary depending on the year and also varies on the scenario describing the overall system loads. Staff argues that a 5-hour window better reflects the uncertainty of forecasting generation and load growth over time. In response to staff's proposal, Public Service is concerned that with a 5 p.m. to 9 p.m. peak period, customers may shift loads to the hours of 4 to 5 p.m., causing the gross load peak to move to that hour and contribute to additional generation needs. It also explains that extending the on-peak period to 10 p.m. could contribute to customer acceptance concerns. For example, customers in public comments have raised questions about how they could operate appliances when they are planning to be asleep. Kroger recommends that the Commission adopt the company's proposed periods because they include a significant proportion of the net load peak hours, in addition to encompassing the system gross load peak hours in the summer. Kroger adds that staff's proposal to establish non-electric vehicle time of use periods from 5 p.m. to 10 p.m. year-round is a reasonable alternative because it encompasses most of the forecasted net peak load hours. WRA suggests that the Commission carefully scrutinize any elongated peak periods in this proceeding. They said long periods will negatively impact customer experience and the acceptance of time of use rates. WRA also suggests that the Commission retain seasonal differentiation in time of use rates to help support the adoption of electric heating technologies, which are associated with higher overall usage in the winter. WRA further recommends that the Commission establish an on-peak period that targets a narrower range of time to maximize the rate's impact and value to the system, arguing that the preponderance of the evidence points to designing the on-peak period around the net load peak. WRA takes the position that Public Service has failed to meet its burden to present evidence quantifying the interaction between the gross load peak and system costs. Energy Outreach Colorado argues that if the time of use rates for residential customers are in fact revised in this case, the record supports a 3-hour on-peak period from 6 p.m. to 9 p.m. EOC argues that staff's proposal for a year-round on-peak period of 5 hours is an aggressive change to the current time of use rate that is likely to exacerbate unintended consequences. Boulder also states that if the Commission approves any changes to the residential time of use rates, the load forecast used to design the rates in this proceeding should match the load forecast used to identify the resource need in that just transition solicitation. And more generally, Boulder does not support a time of use rate design that penalizes customers for shifting usage to times of day when excess renewables are available and emission factors are low. And COSACIA calls Public Service and staff's proposal for on-peak periods excessively long, failing to account for the practical realities of customer behavior. They instead argue that a 3-hour on-peak is easier for customers to manage around to produce the greatest load shift response, such as delaying the charging of electric vehicles or pre-cooling homes. They further argue that a 5-hour peak period would run counter to recent policy changes in other states. COSACIA also faults Public Service for not using the results of its loss of load expectation, or LOE, to design its time of use rates. COSACIA argues that net load better reflects grid needs and pricing signals because high gross load is often matched by high renewable generation. In response to that specifically, Public Service stresses that the analysis in the record in this proceeding to establish on-peak hours based solely on this LOLE analysis may ignore the company's gross load peak and early high net load hours and consequently shift load back to typical peak hours and not support the maximum potential for reducing the company's resource needs. Now, I also mentioned this notion of a super off-peak period. And that's something that WRA develops in the case here, suggesting that when the Commission adjusts the on-peak and off-peak periods, it should also signal to customers the optimal time to use energy based on the times of day that are non-coincident with gross load and net peak load, and when energy has a zero cost, and when there is a high likelihood of renewable energy being otherwise curtailed. WRA proposes a rate compromise, an on-peak period from 7 to 10 p.m. on non-holiday weekends, a super off-peak period from 9 a.m. to 3 p.m. on non-holiday weekdays, and an off-peak period for all other hours. and WRA proposes a modest 20% price discount between the off-peak and super off-peak periods. Public Service opposes a super off-peak rate in this proceeding because it would result in increases to the on-peak and off-peak rates to ensure a revenue-neutral outcome. The company states that the necessary increase in rates may be viewed as punitive to customers that cannot take advantage of that super off-peak period time. As a concept, however, Public Service clarifies that it's not fundamentally opposed to a super off-peak rate, but it objects to that kind of rate being determined as a default time of use rate in this case. Public Service also raises a concern that from a generation resource perspective, energy storage facilities are projected to charge during the hours encompassing the super off-peak period. And should storage facilities need to reduce their charging due to lower available renewable output during those hours, there could be unintended consequences on supply and demand that have not yet been explored or vetted. Staff opposes a super off-peak rate because it adds unnecessary complexity and requires increased rates during the other windows to maintain revenue neutrality. In contrast, the Colorado Office of the Utility Consumer Advocate recommends that if the Commission decides to change time of use rates, it should implement a super off-peak rate to avoid midday renewable curtailments. UCA adds that Public Service's concerns about a super off-peak rate could be addressed by making a voluntary rate requiring opt-in. EOC is also not opposed to a super off-peak rate in principle, but agrees with Public Service that the Commission should not adopt this rate design as a default rate in this proceeding. Boulder generally supports changes to time of use rate design that encourages customers to shift usage to times of day when your renewable generation and curtailment is highest. And the Colorado Renewable Energy Society recommends that the Commission approve a lowest rate during daytime hours. It recommends that the high rates from 5 p.m. to 9 p.m. In conjunction with a super off-peak rate can all be calculated to be effective and revenue neutral. I should step back a bit and also explain the overall positions from UCA and Energy Outreach Colorado. UCA opposes any change to the time of use rates at this time. They suggest instead that the Commission maintain current time of use rates and use program data from the upcoming years to evaluate how customers have actually been responding to time of use and determine if the goals for time of use rates have been achieved. Any adjustments to time of use rates need to account for substantial customer participation and based on data, not just future system forecasts. UCA states that ratepayers have provided the Commission with thoughtful and reasonable public comments opposing the company's proposed time of use adjustments. UCA goes on to state that customers do not view themselves as flexible in their electricity usage, as the Commission may believe, and argues that the adverse effects on individuals who are unable to shift usage outside of the on-peak periods or choose to opt out are well developed in this record and deserve the Commission's attention. Customers have been able to reduce their electricity usage in the current 3 to 7 p.m. on-peak period, but according to UCA, they are less optimistic about their ability to shift usage away from a peak period ending at 9 p.m. And Energy Outreach Colorado also warns that Public Service and the Commission will incur significant costs in the form of customer backlash to change time of use rates in the summer, especially the summer of 2025. EOC further seeks more data to be collected and more thoroughly vetted to be presented under a normal procedural timeframe. So those are the general positions of the parties on the periods, including a super off-peak period and the advocacy for making no changes to the time of use at this time.
Thank you, Mr. Davis. I'll go first and then see where you guys are. For me, I just start out saying that time of use rates can be one critical tool to help keep overall customer bills affordable. As such, my focus here is to help manage utility costs over the long term by aligning customer usage with system needs in real time. And just echoing what Commissioner Gilman has already said, my thinking is driven in large part by the $22 billion that the company has told the financial community it needs to spend over the next 5 years, mainly on new generation, transmission, and distribution. This investment need appears to be driven primarily by a few hundred hours of customer demand that occurs after the sun sets and solar generation falls off, primarily during summer evenings. To put this spending in the context, Public Service's current Colorado electric rate base is about $12 billion. Given these realities, I think we need to ensure that customer prices reflect these costs, which I do not believe is the case under the status quo time of use rates. It seems perverse to me to discourage usage from, say, 1 to 4 p.m. when we appear to have plenty of excess solar generation, particularly going forward, and then promote more usage, particularly EV charging at 7 p.m. once the solar generation disappears, while customer and summer AC loads are still high. So I believe time of use rates produce two benefits. They provide an opportunity for customers to change their behavior in ways that can lower their bills, and second, help to significantly reduce utility capital spending. So for me, I'm prepared to substantially alter the peak demand periods, but believe we need to do it in a way that doesn't raise overall customer bills, works for customers, and permits proper education and outreach. So for me, I do a year-round, either a 4-hour period to avoid the concerns Commissioner Gilman did, either 5 to 9. If we're more worried about the near term, or 6 to 10, which I think is a better long-term fit. And I'd probably do a 3-to-1 ratio. And as I said, keep it constant across seasons. On the super off-peak rates, I can't get quite comfortable with adapting them in this case. To me, it seems like a good idea and creates a further opportunity for individual customer savings. But I think this record was a little too rushed to support this change. And then there's additional educational and marketing concerns. So I declined to do super off-peak rates here, but I'm intrigued and would welcome to explore these ideas in the upcoming, perhaps phase 2 electric rate case. So that's where I'm at, either 5 to 9 or 6 to 10. Trying to narrow it down from some of the staff proposals because of Commissioner Plant's concerns, but can't really get below 4 hours because Commissioner Gilman's concerned. So we'll see if I can stay in the middle or not. But Commissioner Gilman.
Yeah, thanks. Yeah, just like some general comments, probably to start, as you indicated, Chairman, and probably putting it even in more plain language, really the pancaking of electric usage at certain times of day leads to increased costs across the system. And it leads the cost of electric service for everyone going up into the future. And so while many commenters, public commenters in this proceeding noted their home and doing activities that require electricity during that time, unfortunately, that's not altogether that surprising. The combination of everyone wanting to do all of the things with electricity at the same time kind of leads to that peak. But the practical implication of that is that everyone using their maximum amount of electricity all at once causes the wires, the substations, the transmission lines, and all of the generation that we need to be bigger. And bigger means more expensive. And those increased expenses hit everyone in the future. And so, really the point of pursuing time of use rates and time of use rates that are reflective of when the system is the most expensive is to allow for those overall cost savings in the long run. That is the point here, is to result in longer term savings to customers rather than to be punitive or to penalize customers, right when they're home from work. That's not the point. But I do think we have an obligation to properly identify the most expensive times and to present those economics to customers rather than pretending it costs the same at all times of day or something like that, which I think in the end doesn't serve customers well because it leads to increased costs for everyone. And as the chairman pointed out, if we don't provide the right price signal or choose the wrong times, that the result could be more construction on the system to build it bigger and higher rates for all customers. So that's why there's been a lot of analysis in this proceeding, which I appreciate, to help us to understand when the appropriate timing would be to really target that peak as best we can to minimize those future costs for customers. And I think it's important to consider in all of this our prior discussion on revenue neutrality. I know sometimes there's a lack of trust with customers and the utility, but the very premise here is that this will not result in increased revenue or increased profit to Public Service Company of Colorado. Is designed such that they make the same no matter this design. And just being perfectly honest, if we do this well, it will save on their investments in the future and save on what they make in profit in the future by optimizing and minimizing those investments going forward. So just wanted to make sure that was clear. The other thing I think is important to point out is that the analysis in this case, that especially that staff puts forward, staff's entire purpose is to look out for the public interest here and represent what they think is best for customers, indicates that the vast majority, 75% of customers, would either fare the same or have lower bills when compared to the current rates on their suggested time of use structure. So, I think there's some misconception that the ask here or the expectation is that customers move all of their usage and don't do a single thing or turn a light on or cook dinner. And that's not the expectation. The analysis indicates that customers are largely the same or potentially slightly better off with some of the rates that have been suggested here. And to the extent you can move one load of laundry, one load of the dishwasher out of that peak period would only serve to benefit you. So I think that was some important context that I know was brought up in the evidentiary hearing, that it's just not the expectation that customers move all of their load, but even any slight movement could serve to benefit. So I understand that it can feel frustrating to customers to see these windows pushing more into those home and awake hours. But the point is to save on those long-term costs and to really appropriately target that time frame driven by the data, so that we can do that. So just to bring that up, with regard to the super off-peak rate, I think I agree with you, Chairman. I think staff brought up a good point and probably put it better than I could, that the purpose of the time of use will be to provide a strong foundation across the whole customer base to allow customers to understand the relative costs of use of the system and push down total costs for the system, and that could be layered with more dynamic options that have deeper cuts or better options to really reward customers for certain actions that go further, or that could be more dramatic, which could be increasing your usage at certain times of day or decreasing your usage even deeper, especially during kind of the most dire circumstances. And so I think it would make a lot of sense to try to look at proposals for that and tend toward that in the future. I'm not confident that we have a record here to do that, especially because we intended this to be pretty targeted and surgical in looking at those timeframes and the appropriate ratio. But I certainly agree with kind of the premise here that we should be moving toward more of these optional offerings that allow customers who choose to do so to more deeply interact with the economics of the system and get paid for, or save on the performance that they're able to produce under those. I don't think we have what we need here, but I would certainly hope that we can look at more of those optional rates in the future, if that's a super off peak or more real-time rates or peak time rebates, so that we can add those additional layers on top of a successful foundation to encourage more engagement from the customers who are willing and able to do so. But at this point in time, I don't think that was necessarily the purpose of this proceeding, but I would like to express my interest in finding those layers and adding those additional programs as we move forward.
Any thoughts on the exact demand periods?
I struggle mightily with the data to get below 4 hours. I think we could easily end up with a situation where we are defeating the purpose. We push a new peak immediately prior or immediately after. It looks to me like the current data would show 4 to 9 p.m. or 5 to 9 p.m. being the most appropriate. Although I don't disagree with you that toward the end of the period in which we're looking and have data for, it probably pushes later. I think a 3-to-1 ratio can work. I believe it's 2.7 to 1 right now in the summer. So that's fairly similar, and keeping it consistent across the year likely has some benefits. So I think I could support those positions.
Commissioner Plant, anywhere you'd like to go?
Thanks. Yeah, I mean, I agree with both of you, certainly on the objectives. I think that the idea here is to try and pull down the peak as much as possible in order to try and reduce our capital spend on that additional capacity constraint on the system. I absolutely agree with that. I think where I disagree is maybe on the approach and the success of the approach. I think if particularly as people are getting introduced to time of use, I think making it so that they can shift their load more easily and understand ways in which they can do that is going to, at the end of the day, lead to more success. And so that's where I think we need to, I would like to see us find a balance between, what the data says, this much is your peak, therefore that's what we will charge for that entire period of time, and a realization that people, in order for it to be successful, in my view, people would have to be able to move that load around. And so having a shorter period would allow them to do that better. And I take Commissioner Gilman's point about, that is likely to shift some of that load over onto those shoulders, pull down from maybe that middle peak, but move it out onto the shoulders. And I think that's true. But I think that we also have other technologies, storage technologies, certainly, that can address an hour here, an hour there, as opposed to a giant, 4-hour, 5-hour period. So I think that really a portfolio of approaches to addressing the peak, number one, will be more successful, but also I just think aligning a time frame of peak pricing that enables people to be participants more easily, certainly, is going to lead to greater success, and it's going to lead to more actual impact on the system. I think as I look at, as I appreciate Mr. Davis running through all the different positions, because as I listen to all those, I think that at the end of the day, I aligned pretty much with the WRA position. I think they had a 6 to 9, 3-to-1 ratio. I had a 6 to 8, 3-to-1 ratio looking at the net load. I do like the super off peak. I think that just as we're increasing the price at the times when the constraints are highest on the system, decreasing the price when we're, engaging in curtailments, makes a lot of sense. I recognize that, the company has said that they see promise in it, but they're not really sure exactly what the impact would be on the system. And I think that maybe having some sort of an opt-in, or maybe an opt-in up to a certain level, something of a demonstration, basically, to see how that impacts those low load times, might make sense. But I think just as we're trying to shift people's loads away from high cost times, I think we can, employ that same dynamic to shift people's loads towards those low load times. And, to Boulder's point, that's when we have the lowest carbon emissions. But, a lot of that renewable energy is in danger of being curtailed, certainly in the 28 and the 31 projections that we saw. So I think that we maybe have some time for the optimal sort of benefit, and might benefit from an examination of some of those in an opt-in or a demonstration sort of a scenario.
Well, you guys, I mean, so it sounds like Commissioner Plant, you'd be okay with 6 to 9. It sounds like Commissioner Gilman would be 5 to 9. I think on this one, I'm probably closer to Commissioner Gilman. Really, I mean, the Black Hills capital spending was mainly replacing old equipment, which I'm not clear could be avoided by quite so much by avoiding customer behavior. But here we have a utility that's spending a lot of capital, primarily, at least now, driven by 5 to 9. So I worry if we do it 6 to 9, we're exacerbating the 5 to 6 peak. And if we do it 5 to 8, we're exacerbating the 8 to 9. So I think I'm with Commissioner Gilman on the balance. Although I share your concerns, Commissioner Plan, about going too long, and I couldn't get to 5 to 10 or 4 to 9, but I land on 4 hours more than 3. So I guess Commissioner Plan.
The other thing that I was going to mention, and I think you guys mentioned as well, or maybe you ended up in different places on, I can't recall, but I do think the simpler and more consistent, the better. And so, while you don't see the same constraints today on the summer and the winter times, I think just for simplicity, for customer understanding, I would keep with the same, whatever it is that we decide on, be the same in the summer and the winter.
Okay. Commissioner Gilman, you ready to vote on a 5 to 9, I guess 3 to 1 or 2.7 to 1, consistent across winter and summer, or you want to think about it another week or another month? Where are you?
No, I think I'm prepared to do so today. I wasn't 100% clear from Commissioner Plant with regard to the super off-peak, kind of where he landed. I mean, I agree with some of the virtue of trying to encourage usage to avoid curtailments, reduce carbon, all the things. I just don't think it's appropriate for the default time of use rate. I think it's more appropriate for some sort of optional offering as we look at those layered offerings that allow customers with more flexibility who want to interact to a deeper level. First of all, I think it complicates it, but also, as pointed out by the company and I think staff, it actually serves to increase the rates of the on-peak and the rest of the off-peak time to continue to make it revenue neutral. And so I think it's probably more appropriate for kind of a layered or optional offering so that we don't, I question, just as it's appropriate to question how flexible are customers in the evening, how flexible are they in the middle of the day when they're not home to all of a sudden increase usage to respond to a price signal is probably the same question. So I just don't know that it's appropriate in the default offering to go there, but I think is appropriate for some sort of layered optional offering for customers who do feel that they're able to interact with a rate like that. But I just wasn't 100% clear on your kind of
And
thought on the super off-peak.
just one thing for clarity, your proposal is that that would come in a separate process, not now.
Yeah, not now.
All right.
Yeah,
Commissioner Plan.
I'm kind of in the same place. I don't know if it, I mean, I guess it's a separate process. I don't know, but I like the concept of the super off peak. I think it makes a lot of sense. And, you know, I don't agree with the company that it would necessarily shift costs to the other times, because we're basically losing money in some of those periods when we're not using that electricity. And the fact that you could, you know, actually get paid for using that electricity instead of just sending it into the ground makes a heck of a lot more sense to me, and actually could lead to some cost savings for the rest of the customer base. So I I don't know exactly what we're if that were something that would be able to be offered as um, an optional offering, if that happens in this case, or if this case is solely about the on peak, off peak, and, you know, optional structures aren't considered. I don't know.
Well, just want to agree that if we're curtailing wind with compensable PTCs and we can increase usage during those hours, it's really a big benefit to the system and all customers. So I agree with that. All right, it sounds like, yeah, go
I
ahead.
was gonna say that may not be a regular circumstance that happens at the same time of day every single day, you know,
No,
which is what makes it a more unique offering, in that there might be a signal when you understand the conditions will be such that curtailment is going to take place, but it's not an, I don't know how regular to characterize it. It's not every single day, right? That is occurring. So it requires just a little more analysis and understanding, and it may be a more dynamic offering than it's just these times every single day. If you make it a wide swath, it's just these times every single day. There's no way of guaranteeing there's actual curtailment happening every day. So I think that's what leads the prices to increase at the other times of day, is because you have to account for, well, there may not be curtailment. So I don't know what the answer is for these like optional layering, better, deeper demand response options. Maybe there's an M docket here or something that, like, maybe by the end of this discussion, we can have some discussion on what is the next step here to figure out what are these optional things that layer on top that provide these more dynamic options for customers, and how do we get to understanding what the next steps are there. So maybe we come back to that to figure out the next steps, but I wouldn't put it in the default.
All right. So I think we're locking in on a vote on a 5 to 9 period, a 2.7 to 3 differential, revenue neutrality, opt out, and interest in finding a way to pursue super off-peak rates, but acknowledging we're limited here, and the exact mechanism we do to pursue that. Maybe we can all chat with advisors and counsel and think about it and come back next week. And I forget whether I said this, but obviously revenue neutrality. So Commissioner Gilman, would you say that any different, or and I guess implementation no earlier than October 1st, but well before next summer? Is that where you are?
Yes.
Commissioner Plan, can you agree with that, or do you want to dissent, or
I would dissent on the hours, but, you know, generally everything else I think we're okay with.
All right. And I think it'd be helpful for you to write that up if you're willing. The dissent, because I share the concern. I just balance it a little differently, but I think it would be useful to have that laid out if you're willing.
Yeah, are you talking about when we do the order, or before next?
Yes,
Okay.
yes, for the order.
I'm just curious from Commissioner Plant with regard to his difference of opinion on the period. Does going from 3-to-1 to like the current 2.7-to-1 make any difference to you in taking a slightly softer ratio?
No.
Let's
I think there's a better argument for a higher ratio with a shorter period, but I still don't support a longer period.
I would do one more issue, and maybe I'll just say what I think, and we can conclude today. On the assumed load shift, I think staff's proposal of a 1% assumed shift seems like a reasonable way to share risk between customers and the company. And I don't agree with COSA that it somehow puts too much risk on customers. Do you have a view of that? Would you like Mr. Davis to explain it more? But that's the one last issue on my list maybe for today. Do you want Mr. Davis to give a bigger introduction, Commissioner Gilman, Commissioner Plan, or Commissioner Gilman?
I mean, if he thinks that's helpful and necessary for the decision, I would have him do it. But you tell me, Mr. Davis.
No, I don't think it needs to be teed up as long as the three of you know what you're voting on.
Now that we're 5 hours into this.
No worries, yeah. I think it's appropriate to use the 1% load shift assumption. I mean, the entire premise of the time of use rates is that you get some behavior, some reaction to change. 1% is modest in comparison, could be 1%, could be 2%. I don't think we're way overdoing it with that assumption as to the shifts, but in calculating that revenue neutrality, what is our expectation that customers will do? I think it is fair to assume that we'll see a 1% shift. After all, that's the rationale, that's the reason for adopting the rates. So I think it would be odd to simultaneously assume zero reaction or behavior change when that's part of the stated intent here. So I think a 1% shift is a fairly logical place to go.
Commissioner Plant?
Yeah, I mean, I think, whatever number we pick, it's going to be, an estimate. And, the hope is that it's going to be higher. It could be lower, but I don't know that we really have anything to base some sort of alternative number on. And I think that you do need to pick something in order to make an estimate. So it makes sense as a place to start.
All right. Mr. Davis, should we break here, or do you want to? I don't really have any other issues that cause me heartburn. Do you want to try and resolve it today? Well, let me check with Commissioner Gilman. There's probably 8 or 10 other issues that probably take 20 or 30 minutes to resolve it. Do you want to try and do it today or push it to next week? I think we got through the core.
I think we got through the core of a lot of the issues. I think we have a fairly long agenda for next week, so I'm not sure it would appear next week. It might appear the week after. But there's also not an incredible rush given our implementation timeline discussion. So I'd be okay to complete this, in 2 weeks or whatever you think is the appropriate time to bring it back, Mr. Davis.
I can do either way. I can bring it back in March. That would be fine. Next week's agenda is pretty full with the public service distribution system plan, its virtual power plant. We'll be talking again about the just transition, and I'll be presenting a new case for the first time, which is the request for a CPCN for the mountain project. So I think we're full as far as discussion items next week, but when we have a full bench in March, we can bring this back. But I'm also happy to continue. There aren't very many more decision points left, and And I think we could do it in 20 minutes.
Commissioner Plant, you have a preference?
Yeah, let's just get her done.
Yeah, that's where I'm at. If that's okay with you, you want to take a 5-minute break, Commissioner Goman, or you just keep going?
You can keep going.
That body language looked like keep going. All right, Mr. Davis, if you could get us through the rest as quick as possible, that'd be great.
Sure. But before I do that, I just want to clarify, did the majority agree to a 3-to-1 price ratio?
I think so.
Okay, so it's 3-to-1 and it's year-round 5-to-9 for on-peak.
Can you confirm, Commissioner Goman?
Yeah, I mean, I'm open to 2.7 to 3-to-1, depending what you think, Chairman. I was trying to see if Commissioner Plant could be won over. In acknowledgement of the long time frame, I can see some rationale to stick with 2.7 to 1. 3-to-1 is a little more aggressive.
I'm indifferent. You can choose.
All right, well, let's, in an effort to moderate, to recognize Commissioner Plant's concerns here, I would stick it to 2.7 to 1 year round, which is a slight moderation of staff's proposal, which is aligned with the peak to off-peak ratio that customers already see in the summer. So I think just an effort at moderation to recognize the change in hours and things like that.
That's good by me. That doesn't create any record concerns or implementation. No. Okay.
No. Okay, well, thank you for that clarification. So we've talked about the principal time of use rates for residential and small commercial, because they're very much aligned. But the company has also made proposals for non-residential electric vehicle rates. But those proposals appear to be uncontested. For commercial EV charging rates, staff supports the continuation of the current 5-to-1 price ratio as proposed by the company. And WRA also says that it supports Public Service's proposed time of use periods and price rate ratios for those rate schedules. But WRA encourages the Commission, again, to add that super off-peak period to those rate structures as well. I recommend that the Commission approve Public Service's proposals here, and consistent with the previous discussion on the super off-peak, to postpone consideration of that for adoption to a future proceeding.
Makes sense to me. Commissioner Goman.
I agree.
Commissioner Plant.
I also agree.
Okay, thank you. And then there are some other approvals that are uncontested that Public Service would like. Approval of the extension of the company's secondary general time of use pilot for an additional 2-year period, and the modification of the electric commodity adjustment as part of a future quarterly ECA. Those tariff changes are uncontested, so I recommend that the Commission grant those 2 requests. Commissioner
Goman.
I agree with you, and I would emphasize I'm very supportive of continuing the SG time of use pilot. I really hope we see a good uptake here, ensuring we're incentivizing those larger customers to avoid the same peak window. Certainly aligns with the intent here, and I hope see good customer uptake of that pilot.
Commissioner Plant.
I agree.
As do I.
Okay, so the next series of decision points have to do with what Public Service will tell customers to give them notice about these rate changes, to talk about the opt-out option, and to talk about a rate comparison tool. So the big question is whether the Commission needs to order Public Service to provide these specific things. In its case, Public Service states that it will provide customers with practical and actionable advice to show them how they can take advantage of time of use rates without major disturbances to their lifestyles. The company says it will communicate to customers their opt-out rights from Schedule RE time of use to Schedule ROO, which is rate opt-out. Public Service says it will create an online tool to permit opting out, along with that new rate comparison tool to allow customers to compare bill projections under the updated schedules. Energy Outreach Colorado requests that the Commission specifically require Public Service to notify customers via email and mail of, one, what the new rates are, two, the ability to opt out to Schedule ROO, and how to access the rate comparison tool. So the question is, should the Commission explicitly require those three things as requested by EOC?
Do you have a recommendation?
Yes. Advisors are primarily concerned about a required notice if it comes without proper context. And I think that's proper context is what comes through what staff describes as detailed customer education. So on this point, I think the Commission should not be too prescriptive, but I do see merit in the request to direct the company to provide customers notice by email and by mail, and it should clearly explain what these new time of use rates and periods are, with an emphasis on revenue neutrality, to describe how customers can opt out, and to offer directions on how a customer can access an online rate comparison tool.
Makes sense to me. Commissioner Goman.
I agree with that, and I might make a few friendly, really minor amendments. I certainly agree with your first point in emphasizing the revenue neutrality, so customers understand this is intended to not make any more or less money for the company. But I would emphasize it would be very ideal for the company to use terminology that might be more widely understood by customers. They should speak to customers, not to us, in the terminology that they choose to use in this notice and these communications to ensure that it's clear and can be easily understood, not necessarily using regulatory speak, which I get we use around here, but we want to make sure that the language is targeted and really appropriate for customers that they use there. The only other thing around the rate tool, well, maybe there's another decision point around this. Is there, Mr. Davis? Am I jumping the gun?
It's fine to jump the gun. I am going to recommend that the Commission direct the company to make a rate option tool available on its website that would compare, usage under the new schedule as compared to opt-out, and to also require the company to permit opt-outs to incur online through the My Account portal.
Okay. Thank you. Sorry for they're related to me since the first one implicated directing customers to the online rate comparison tool. I'm supportive of your second recommendation here as well. I think it's obvious, but just want to state in the timing for the implementation of the rate comparison tool, that would have to be ready and functional and able to be accessed by customers before these communications go out, which is well in advance of the actual implementation. And it seems to me, if the idea is that customers may be able to shift some amount of their load out of the peak time, it seems to me it would be most productive if that tool could allow customers to, yes, calculate their actual kind of historical usage during those times and see how they would fare. But also, if there could be some rather generically loaded options, move one load of laundry out of the peak time a week, move one dishwasher load. These are fairly obvious energy uses. Like, it doesn't take a lot of work, I don't think, for the company to come up with what that amount of energy is that moves. But I think it would really enable the customers to understand the impact of their actions. Change your cooling up 1 degree. These things really help customers be able to grasp not just on their historical usage, But I think the premise of a lot of the public comments is the expectation that customers think they should be moving a ton of usage. As we said, it looks as though customers will fare the same or better for the majority of customers as is without changing their usage. But I think it would be really much more helpful if this online tool also allowed just a few of these preloaded options for customers to really like visualize and understand what moving a little bit of usage looks like, so they can understand how these rates actually affect their life, and if they want to make those changes to their usage, what they could expect the outcome to be. So just a suggestion for my colleagues. I don't think it's that complicated, but that's the premise of the time of use rates, is people might move a little usage. So to only have a rate comparison tool that looks at what you did last year or last month before this was a thing misses the point just a little. And I think providing a few of those options in the online tool would be more useful.
I'm fine with that. Commissioner Plant?
Yeah, I think that makes a whole lot of sense. I like the scenario sort of planning. Yeah, I support the recommendation.
All right, Mr. Davis, keep us going.
Yes, so I think Commissioner Gilman addressed much of what Energy Outreach Colorado was requesting in terms of specific outreach and education. But I'd also like to mention that the Colorado Renewable Energy Society has asked the Commission to require public service to communicate some specific information on the modified time of use rates. That these rates are designed to minimize the cost of producing and delivering power with benefits to all customers. Power use during daytime is cleaner and lower cost than power use at night going forward. The majority of hours, including weekends and holidays, are lower cost than the opt-out flat rate. And it's useful to have practical examples of saving money on the time of use rate. So again, Commissioner Gilman took a lot of those concepts there too. And I'd like to just express some appreciation for CRES's advocacy on this, because it's useful for the record to have that kind of information in the record. Nevertheless, I suggest that the Commission again refrain from being too prescriptive on specific messages, but I do see some merit in suggesting that public service confer with stakeholders in its time of use stakeholder group on the information and messages to be used as part of its detailed customer education campaign. And this would be on top of the language that would be in the order pursuant to what Commissioner Gilman just stated.
I mean, I certainly don't disagree with anything CRES is trying to communicate, but hear your caution about trying to be too prescriptive. So maybe some language in the order acknowledging our general agreement with it, but giving the company the discretion about how to do it best. Commissioner Gilman?
Yeah, perhaps we can indicate that those are very reasonable things for the stakeholder group to start with. Right. To discuss. I mean, I agree with you. I don't come up with anything I disagree with. You know, and I think evidenced by the public comments, I think that the communications on this are challenging, it appears, when the analysis in the proceeding shows that 75% of people will fare the same or better. Yet most of the public comments, the people feel like it's really punitive and they'll be harmed by this. Clearly, we have a communications challenge here in ensuring that customers really understand the analysis and economics here. And so I think the success of this program and seeing most customers stay, on the default rate is important to the overall optimization of costs on the system going forward. And so just want to express in the order how seriously we take the outreach and education, and really kind of the gap or the problem in perception that we have already with time of use rates. And it's going to take a very serious effort. So hopefully a stakeholder process there and the company's efforts will be targeted at making this as successful as possible. And I hope we could express that.
That makes sense to me, Commissioner Plant.
I agree as well.
All right, we're getting there,
Okay,
Mr.
and
Davis.
so WRA asked the commission to direct public service to continue to convene that stakeholder group. CRES supports a requirement for ongoing quarterly stakeholder meetings. The commission directed public service to conduct stakeholder outreach prior to making the filing that initiated this case. And I suggest that such stakeholder efforts continue and that the commission direct public service to work with that stakeholder group as suggested by WRA and CRES to refine the communications.
Makes sense to me, Commissioner Goman.
I also agree.
Commissioner Plant.
I agree.
To you, Mr. Davis.
Okay, we're getting close to being finished. Energy Outreach Colorado requested that there be a technical conference for the final rates to be presented. I think there's some merit in that, and maybe we can schedule that technical conference to review the calculations for sometime when it matches the commissioner's calendars to just confirm that the calculations are meeting the expectations based on today's deliberations.
That works for me, Commissioner Goman.
That works for me.
Commissioner Plant.
I agree.
I think the commissioners have talked already about the question of filing directives or other rate designs. This was something that was raised by COSACIA, Boulder, and WRA in their cases here. I do think that WRA makes a very good point that the commission should decline to use this proceeding to direct the exploration of other similar voluntary rate offerings because the company is already committed to investigate a residential peak time rebate pilot as part of its demand side management program. This is part of the 2024 to 2026 DSM beneficial electrification plan. And so I agree with WRA that the commission should decline to use this proceeding to direct anything specific. But as the commission has already said, it's very interested in seeing new rate designs being presented in future proceedings.
Commissioner Goman.
Yeah, Mr. Davis, when's that expected in the 2026 DSMSI?
I'm not sure the exact date when the peak time rebate pilot is going to be implemented, but WRA points out that the company is already committed to investigating that as part of its program offerings in that earlier proceeding. And I think WRA's concern is that the commission just needed to understand that some of what has been proposed by parties here as a directive to public service, the company's already agreed to look into in a future proceeding. I'm not sure that there's a directive on when the next phase 2 electric rate case is going to be filed. But I do think that in this proceeding, the commission can express its interest in looking at, for instance, an opt-in super off-peak period option or other rate designs along those lines. And in the event, maybe the commission could want to say that in the event that a pilot has not yet been introduced pursuant to the DSM plan, that also be part of a future phase 2 rate case.
Yeah, I'm trying to figure out, I mean, I think peak time rebate is a very reasonable tool to be looking at here, and I'm glad it's already agreed to. My guess is that would come in the 2026 DSMSI, but I'm not sure. I know that offhand.
I can certainly investigate that
okay.
when developing the correct language for the order.
Okay. I think part of I want to find like what is that venue? It's great that they'll bring forward that one offering, that one idea. But like what is the whole apparatus we're building? You know, of these optional things that build on top of ideally a successful default time of use situation that provides kind of the full array And I want to avoid taking them just one by one piecemeal and not saying like, what is the whole apparatus we're building that customers who can and are interested in going deeper and more flexible and really interacting with the system can participate in. Peak time rebate is one, it doesn't get to the super off peak, right? It's just, we'll give you a benefit if you stop using it at the maximum times. It doesn't incentivize that use of curtailment or that use of the super low cost energy. And so I don't know, like I'm fine with good. I'm glad that that's coming in, but I'm also trying to figure out like what is the whole apparatus we're building and how do we have in a proceeding that discussion around what should all of the offerings be or all of the offerings right now. It seems to me that's the next DSMSI proceeding, and maybe we should go back and review kind of the decision from the previous DSMSI, where I think we indicated that one of the things we were most interested in was the companies showing us kind of the whole ecosystem of demand response and demand flexibility programs and kind of that array. That discussion probably still misses this bottom tranche of the encourage usage during certain times. But I just want to make sure we're set up to have this full discussion somewhere. And it's great that this is coming in, but this is just like one particular flavor of things we could consider or offer. So I don't know if that's like the most appropriate for the next DSMSI and how we indicate in this decision that we want to have this full discussion in one place.
Commissioner Pyatt? Oh, sorry.
No, I was curious if Mr. Davis had any idea, like is DSMSI the right place? I don't know that you know offhand what we ordered in the previous DSMSI, right. But I know we talked about this whole ecosystem of demand response and demand flexibility and really like seeing demand response as more than just interruptible rates, right? And exploring what do you do for the intraday peaks to avoid running gas generation and like VPPs and like this whole apparatus. And I'm just worried we don't really have a venue right now where we're directing this whole conversation will take place.
Right. I would be most comfortable coming back with this. It would be a short discussion, I think, in the future, but I understand what you're looking for, but I need to do a bit more research on what has been committed to and also thinking about what you just said with respect to the recommendations that were put forward by COSAC and Boulder.
Commissioner Plant, anything you'd like to add?
Nothing to add.
All right, last two issues, Mr. Davis.
Okay, so CREZ recommends that the Commission order Public Service to complete a planning reserve margin study and an ELCC study with 2% of the residential energy use shifted out of peak hours into the daytime hours from 8 a.m. to 3 p.m. And this would be to address the uncertainties brought up by the company and the commissioners concerning the potential effects of shifting load into the daytime. According to CREZ, this would clarify the issue of whether small changes to the gross load peak during daytime hours due to a load shift actually increases capacity requirements despite the ability of PV to serve this load with a higher ELCC. So that's very technical talk, but I think you know what CREZ is getting at. And so the question is, should the Commission order Public Service to complete that kind of study or studies?
So I'd just say I appreciate CREZ raising these issues, and I recall that we did some analysis, sort of kind of maybe along these lines in supplemental direct testimony in the 2021 ERP. I think Mr. Landrum was the witness, and there we assumed that I think it was 200 megawatts of load, maybe closer to 3%, was shifted an hour or two earlier, and tried to quantify the benefit, which I think we found was significant. So since this was quantified in the last ERP, I didn't request it in the JTS supplemental direct testimony this time around, as we had bigger issues with the load forecasts and other issues. But between the CREZ advocacy and the prior supplemental direct testimony in the last ERP. I think we have a rough understanding of these issues, and we'll be exploring them further in the JTAS. So I don't think I'd order it here, but maybe just acknowledge that this is an important issue, and we're going to continue to look at it. And some appreciation to Chris for building the records on this. So I don't know, Commissioner Gutman, you okay with that?
Yeah, I think that's a reasonable place to be right now.
Commissioner Plant?
I agree.
All right, one more issue, Mr.
Right.
Davis.
Right. So according to Energy Outreach Colorado, Public Service is largely taking the position that the proper place to consider equity consideration, including how revisions to the time of use rates may affect energy insecurity, is in its Energy Insecurity Working Group. But EOC states that such considerations have been outside the scope of that working group, and though the working group has primarily focused on estimating energy burden households. EOC states that it welcomes the suggestion by Public Service that the working group should begin consideration of the development of any specific time of use rate options for income qualified and disproportionately impacted community customers. So EOC recommends that the Commission order that the Energy Insecurity Working Group to investigate an IQ customer-specific rate using actual usage data and undertaking surveys of income qualified customers. So the decision point is whether the Commission should order the Energy Insecurity Working Group to investigate an income qualified customer-specific rate. I can provide a recommendation if you want.
Yeah, maybe that's the best way forward.
Okay. Advisors here at the Commission share many of EOC's concerns about affordability, and that's why we are working with the Commissioners to bring a more structured Commission-led examination of an income-qualified customer-specific rate and other matters related to affordability into play. We're concerned that the company's working group lacks the focus and the momentum to really address these kind of issues, and we want to prevent delays and unintentionally present a new set of obstacles for the Commission in making progress in this area by directing that working group to take up this issue. So while we appreciate EOC's suggestion, we think the Commission should decline to direct that group to investigate an IQ customer-specific rate, but EOC should know that we are working with the Commissioners to bring a more structured Commission-led examination of income-qualified customer-specific rates and other matters related to affordability into play in the short term.
So appreciate the advisor leadership, and just say if we can keep the timing so we can frame these issues up for the whenever we have the next phase 2 electric rate case, which would be where we could actually implement this. That'd be great. Like you say, just share all the affordability issues EOC is raising, and I know there's legal issues with doing this, but if we could, like I say, frame it up for the phase 2 rate case, that'd be great. So, Commissioner Gutman?
Thanks, Mr. Davis. I agree with your recommendation.
Commissioner Plant?
I agree as well.
So I guess, Mr. Davis, we'll do, since we have at least one dissent, we'll do a TBC order.
Correct? Yes, we will do that. Thank you.
Anything else on this one?
I think we've covered everything we need to. Thank you.
So this is a new record for me, over 5 hours. Commissioner Gilman, any final comments before we get on with our lives?
Nothing additional. Thanks.
Commissioner Plant?
Nothing additional. Thanks a lot, everybody.
Yeah, thanks to you. Thanks to advisors. Thanks to council. And thanks to you both for keeping things moving and getting through everything. With that, we're adjourned.